nation, under God, indivisible, with liberty and justice for all. We had an executive session preceding this meeting, and all the commissioners were present, and we discussed personnel matters, litigation matters, and real estate matters. Item B is off the consent agenda, and item F, Biomed, has asked for an extension under public engineering, so that will not be on the agenda this evening. So I'd like to... Pardon me? I'm sorry, the first one, Kevin's the first one?
Correct. It is the first one under
First one.
HARB 2015-05.
124 Bloomingdale Avenue?
Correct.
Okay, so that is not on the agenda. So could I have a motion to approve the consent agenda?
Well, hold on. I'd like to pull out C as well, please.
Can I have a motion to approve the consent agenda without the first dot under B and number C?
Second.
Okay. Does any member of the public want to take anything off the consent agenda? Okay, all those who approve the consent agenda, say aye.
Aye.
Opposed? Passes 7-0. So item C, authorization to receive bids for 2015 Super Pay Resurfacing Program. Can I have a motion to approve that?
So moved.
Can I have a second?
Second.
Discussion?
My question is, just want to go through the streets that are on the list here and also get clarification on how this differs from the approval we did last meeting or the meeting before for resurfacing. Is this the same streets or is this different?
This is different, Commissioner Booker. So last week, basically the Board of Commissioners approved the award of the contract of the 2014 program. It was a carryover due to weather. This is the 2015 proposed program. So you'll have two projects running concurrently. One was a carryover from last year, and this is the 2015 project.
Okay, and so explain to me the fallout list. The fallout list is based on the bid price, or is it based on schedule, or is there flexibility, or is it based on both?
So when I put together an estimate to determine how many roads we can do, I use estimated numbers, real numbers, and some history. And I plug them in, and we come up with our budget number, which is actually comes right to the budget of $721,194. We have a lot of roads on the list to be paved. If the paving is favorable, if the bid is favorable to the township and comes in considerably lower than the estimate, we go to the fallout list and try to pick roads that fit into that delta and pave them. And I also have to list them on our PennDOT sheet should we decide to do that. They want to see what roads you would do aside from your main paving.
So historically, do we get one or two or all of the fallout list, or usually don't get to it?
It's probably been 50-50. Occasionally, we can grab an additional road. Other times, we cannot. And there's actually been times when we've had trouble completing the main list because there are some unforeseen conditions that can affect the price.
That's all I have, thanks.
Steve, can you remind me, I know at the last meeting, there was a road in the first ward, Radnor Street Road, the very end near Aberdeen Terrace. I'm
Correct.
trying to remember if Eagle Road was on there.
Yes, so we have Eagle from basically State Route 30 to North Wayne.
That whole stretch, okay.
Yes, sir.
Thank you.
Any member of the public have any comment? All those in favor say aye. Aye. Opposed? Passes 7-0. All right, the next item is a resolution authorizing the township. Can I have a motion for that?
I move we approve the motion.
Second?
Second.
Commissioner discussion?
The,
Number 2.
So we're voting on Resolution 2015-57?
Yes.
Okay.
The director's here.
yeah.
You want to come up and just, sure, why don't you come on up and,
Hi. I'm Claudia McBride, Executive Director of Mainline School Night. I'm also a resident of Radnor Township.
Okay. And we're authorizing $20,000 for the painting of the Kutzenberg?
Correct.
Hartford Park?
Yes.
Okay. And you've been doing a number of repairs, and this is over and above what?
Yes, yes. The bid is for $46,800 for the exterior painting of Kreutzberg. It hasn't been painted since 2001, so there's a correction in your packet. It's 2001 instead of 2003. And at this point, there's, there's damage to the wood and so on. So Mainline School Night has raised over $20,000 toward the exterior painting. And we're requesting an additional $20,000 from the township to help with that.
Okay. Any commissioner comment, questions?
Well, I'm just going to say this $40,000 project is over and above all the other maintenance that the Mainline School Night has done for the last year over. This is just one of those extraordinary capital expenses.
Correct.
And I reviewed our lease that we all agreed to, and it's pretty clear under the terms of the lease that it's our responsibility for large expenses over $20,000, big capital expenses, that we would bear this. So it's not really out of the goodness of our heart that we're doing this. This is our responsibility to do it on our building. It's our capital obligation.
And to that point, we have already spent $38,000 this year on repairs and maintenance.
Okay.
And contractually, we have demanded $20,000 a year, so you've gone over and above what you had to spend to begin with, and then there's this capital expense above that.
Okay. Any other commissioner questions?
Yeah, what are the colors? Are you going to repaint
So-
exactly the way it is? Or
No.
what's,
No, I don't think the community would be pleased if we painted it blue and salmon. So what we're doing right now is, it looks like Nolan Painting will be doing the job, and they have consultants who will help us with the Victorian color scheme. So I would note that we have agreed to a simpler color scheme that is often used for Victorian buildings because the price is so much better. So we will be working with consultants to make sure that, it's appropriate without over the top.
will there be another submittal that'll come back before the board, or what are we, what input or review does the Board of Commissioners get on this?
I'm more than happy to share the color schemes that, we're looking at, and we'd like to go with something neutral that wouldn't be offensive to anyone. But, anyone who would be interested in reviewing color schemes, we're happy to share that. Is that what your question? I'm wondering, is that what you're asking? Or
Well, no, so what you're saying is that there would be no further review by the Board of Commissioners with respect to this work?
For the approval.
Oh, for the approval? No.
I assume
Well,
you're going to get Greg Pritchard to come in, or the Historical Society?
Well, we're not on the register. And, in terms of priority for Mainline School Night, it's really function and keeping the building from having irreparable damage. So we don't really have the kind of budget that would be required to do everything that a building on the register would get. Again,
No, I
we're
was just
looking-
referring to your color scheme.
Again, we agreed to a simpler color scheme. We'd be happy to share it with with Greg and the group at the society, but we really can't go over, the budgeted amount. Yeah.
Well, I understand
Yeah.
that, but one of the reasons that we undertook this whole effort with Mainline School Night was the preservation of that building. So we didn't have to tear it down,
Got it.
so.
Well, I'm confident that you're going to paint it a neutral color, so.
If you would, I'll give you a card, if you could send that, so I'd like to take a look at that
Sure.
with you.
Sure. Yep.
Okay, thank you very much.
Okay, thank you.
Anyone-
Claudia, before you, can you stay, after we vote, I have one or two questions for you.
Sure. Should I stay up here? No.
You just sit right there. Does any member of the public have any comment on this? All those in favor say aye. Aye. Opposed? Passes 7-0. What did you have, Jim?
Now, please come back. You and I spoke back in February
Yeah.
about the problem of access to Hartford Park and to your building.
Yeah.
And I said I would look into it. I communicated with Commissioner Booker, and he kind of educated me on the issues. But I'm wondering if we might revisit that now with our solicitor being here, and could we get back over the issues of, is it possible for us to obtain a, I guess it would not be an easement, but maybe a informal agreement with the owner of the developer there to allow members of the public to traverse his property to get to the park?
Well, the issue, as Commissioner Booker knows, really comes down to getting together with Brandywine on that side of the property, alongside of the driveway that services the 2 Bentley lots. So that's where it's been left, Jim, probably 2 weeks ago. We need to meet with them, and then someone needs to go out there and engineer a solution. My understanding, I think, there was some preliminary discussion with someone at Brandywine that they were willing to talk about an easement. It would be some kind of an easement, but primarily, I think, on their property.
Yeah, we haven't discussed it with Brandywine, at least I haven't formally made some initial contact on it, but I guess the answer, Jim, is based on where we are right now, it does seem very difficult to envision an easement in the area that's already developed, either with paving or on the other properties. Steve Norsini and I did review the area and are working on a potential resolution that would provide access and would service the area. But there is a lot of work to be done on that. We've done just preliminary review, so there would need to be some surveys, or need to be some discussions with Brandywine and perhaps with others, although I don't see that as the case, and some plans made. And so I think we have to put together a package
All right,
for the board to
Are you
review.
going to lead on that? I'm available to help if you wish.
Can I just update a little bit? Mr. Brosman and I had a sidebar conversation here, and we had tried to set up a meeting with Brandywine, and I think their person was away. I've been away, and I'll get together with George this week, and we will get some dates and let both commissioners know when those dates are going to be, and then we'll start that process. But it's not so much Bentley, it's Brandywine that we need to talk to and have that discussion with.
Okay, thank you very much. And
Thank you.
for
Thank
all the
you.
good work you're
Thank
doing.
you, Claudia.
Appreciate it. And next, we have a resident discussion on the Villanova University project.
Good day. This evening, I am speaking for myself as a Radnor resident of over 4 decades. Prior to living in Pennsylvania, the hazards of Lancaster Avenue at Villanova were unforgettably etched into my heart. Tragedy struck me as a college senior when a dear friend, newly wed to a classmate of mine, was hit by a car. He was instantly killed while waiting to cross Lancaster Avenue to attend class as a graduate mathematics student at Villanova University. An accident snuffed out a life of promise and hope, leaving broken hearts filled with grief. Now, some 40-plus years later, I am familiar with the promises and proposals of those who speak for Villanova University. At times, hope has been replaced with dismay. Many of you in this room know, better than I, that options and alternatives, once proposed, have been removed. Better ideas have been forgotten. And what we have seen or been led to believe has not been realized. From my experience, I have learned that trust, once broken, is hard to restore. Villanova may be a good neighbor, but residents may not have confidence in their word. I implore you, as elected officials, entrusted with the public good to promote accountability and restore faith in good government. Actions speak louder than words. Thank you.
Good evening, ladies and gentlemen. My name is Sigmund Fleck. I represent Tish Long, who has objection to the resolution as presented with respect to the university's housing project that's on your docket this evening. If you'd bear with us just a second, we have a PowerPoint to help elucidate certain of the points, and we'll go through it very quickly. The prior speaker did provide an eloquent and articulate basis for some of the grounded concerns my client has with respect to the current project, the safety, health, and welfare concerns that this project brings to light, and perhaps even more significantly, the fact that this body, and when I say this body, I obviously don't mean the makeup facing us here this evening, but what I'm referring to is this body in its historical capacity, some of whom are more historical here than others, Mr. Higgins. And I mean that with all due respect, sir.
Take it as a compliment, thank you.
We know that this issue and these concerns have been before this body before. And if we could just take a brief look at the screens, and what we know is in the 1990s, concern over safety at the subject intersection, which is Ithan Avenue and Lancaster Avenue. And I believe that's the same area that the prior speaker was speaking about. Go to the next slide. We know that this body was very concerned then with student public safety because of a series of resolutions that came into existence, enacted by this body in the 1990s. You have Resolution 9004 of February 26, 1990. And this body installed as a condition in the resolution that was then passed, see that last bullet point, best efforts to be used to complete construction of the then proposed pedestrian bridge on or before occupancy of the proposed dormitories. And this is from February of 1990. Now, what best efforts? Best efforts. Alex is from Boston, and that's how they actually spell that word in New England.
I try.
What best efforts mean, I don't exactly know, but I glean from it at a bare minimum that this body was concerned then. We know a couple things that I think we can all take common sense notice of. Between 1990 and 2015, we have not had a reduction in vehicular trips up and down Lancaster. I think to the contrary. I think I see a friend. Could you just address the board? I'm sorry? Just address the board, don't go to the audience.
Mike, Bill.
You're addressing the Board of Commissioners. Don't bring the audience into your discussion by looking at them. Look at us. Okay, thank you.
My pleasure, sir.
Okay, thank you.
So we know that this body is aware of the fact that vehicular traffic on Route 30 has not declined. We know that the student body has not decreased in size. We know that congestion in general in this area has increased. We also know something else, don't we? That Resolution 9030 of October 22nd, 1990, this body moved progressively from requiring best efforts to requiring that by March 31st, 1992, plans for the pedestrian bridge be completed. We further know that this board said by December 31st, 1993, construction had to have been completed. We all also know that today there is no bridge there. So, next. We also know that concern over this situation is widespread. There's plenty of press about the situation at this intersection. And we also know that pursuant to Township authority, a certificate of occupancy was actually issued, the bridge never having been built. So the question really is, what became of that condition? Did it just go away? Was it removed in a public meeting by public vote, as should be required? We don't think that's the case. We think for some reason, somehow, that condition simply evaporated. And we think that the people of your great township deserve an answer. They need to know why a condition that they relied upon in good faith, voted on in public, at a public meeting, simply went away. We know that after that went away, there's also discussion about not a bridge, which this board required, but a tunnel. Was there a public meeting and a public vote that authorized a waiver of that condition, or removal of that condition, or a transformance of that condition from bridge to tunnel? We think not. We think that in the 1990s, that communications were had, decisions were made, not openly, not as is required under Pennsylvania law. And we think that the certificate of occupancy should not have issued, and that that condition, the condition imposed by this board, was never lawfully removed, waived, or satisfied in any way, shape, or form. And the people of this township need to understand, and have a right to understand, why that was. The prior speaker spoke of trust and a loss of trust, and how delicate and fragile it is. And now we have a new development plan with a proposal for a bridge, not at the subject intersection, which is, as everybody that lives, travels, and works in this area knows, is the problem, but farther east. Is this bridge to be as amorphic, as fleeting as the prior bridge? Our client objects to this development proposal, implores you to not approve the preliminary plan, to vote down this resolution. There are outstanding conditions from 1990 that this body imposed that have never been met. And we would implore you to not pass this resolution tonight for preliminary plan approval unless and until answers can be had for the residents of this township. Thank you.
Thank you. We will have the solicitor address that at the proper time when we're discussing Villanova project. All right, now we have public participation.
Do you want discussion of Villanova now or later?
No, we want to join the Villanova later, when we have it on the agenda.
Would it be possible if we rearrange things slightly, since the attorney is here to speak to Villanova? Is it possible to rearrange the schedule slightly so we can talk about Villanova and get that so whatever questions you have for the attorney, he would be available for you? Is that
Well, we have a
possible?
very
Would you-
short agenda. It's only going to take a few minutes to do the
Okay,
agenda.
all right, then I won't make any comments on
Yeah.
Villanova, and we'll wait till
Okay.
the topic's discussed.
All right.
Thank you.
Hello. My name's Kimberly Rolfe. I live at 110 Pine Tree Road. And for 2 years now, I put an email in stating that the safety with the speed and the high traffic, it's a definite safety issue for the families and especially the children on Pine Tree Road. It's been 2 years, and I am here just to see where we are with that process and if we can be on the agenda for the next meeting. And if there's studies out there, when those will be permitted for the community to see, and where we are with this, because it's been an awful long time.
We had asked the police to do some additional review, and I have not had a chance to, I haven't seen anything, report from that. So we're evaluating all of the information from the constituents, as well as I say, some additional information, including clearance of the right-of-way, an additional review of stop signs. And so I wanted to review that, and as soon as I have something, I'll come back to the constituents there on Pine Tree, and we'll go through.
Okay,
So
great.
I expect that to be relative. I expect it this month, I guess, this month.
Okay, and then do you think we can be on the agenda for the next meeting on June 1st, or?
I don't know. We'll have to take a look and see what the police have come up with, and then we'll evaluate the options and move from there.
Okay, I just.
But you're first on my list, Kim.
I greatly appreciate it, because I know we've had 2 traffic studies, and I just feel like the whole situation's been a little bit of a delay, and we're just concerned, because every day that goes by, it is a safety issue. So thank you very much.
Kimberly, you and I have had
We've met multiple times.
a lot of
Yes.
discussions. I've been to the
Yes.
staff traffic committee meetings once or twice. I'm fully supportive of helping you, and you're really Commissioner Booker's constituents primarily, but since we're a collegial body, we all represent you, and I sympathize with you. Pine Tree is a speedway. I think if you cut right to the heart of things, if the residents would get behind stop signs at 1 or 2 of the locations on Pine Tree, Cricket and
Rock Rose.
And this is my own personal opinion now. I don't speak for Mr. Booker or anybody else. And abandon your wish to have speed humps on that street. I think you would see a solution sail through that would be satisfactory and help you.
And it wasn't a wish for speed humps on our end. It was the engineer, Amy, who presented lines, speed humps, or a median. And it was advised
Yes.
speed humps would be the cheapest, most efficient,
Yeah.
easiest solution. So it's not the community's wish. We just want some type of
Okay,
calming and
good.
safety.
Then
We're open to any of that.
Yeah.
And I know the community would definitely honor those stop signs, but that would be around the blinded curve. It would not address the top or the straightaway towards King of Prussia on Pine Tree.
We'll have to work on that. I know that Gilmore and Associates, represented by Ms. Kaminsky, is she here tonight?
Commissioner, she is not.
In their report, they said that there could be a maximum of 8 speed humps on Pine Tree.
Maybe if I can just add some
Yes.
brief information to this. After Commissioner Booker had the meeting with the residents, we had asked, and Commissioner Booker had asked, for Amy to go back and look at the intersections again about stop signs. I can say that 2 of them have met the warrants for that. There's one other one she has to look at. So I know her report will be coming shortly, so Commissioner Booker will have the chance to look at that. If we can get this complete and have the commissioner take a look at it, if he is ready, I know we've got a tight timeline because the next meeting is next week right away. Maybe it's possible that either next week, which might be a little tight, but the first meeting in June, we could have something prepared, so.
That would be
we will look at
fantastic.
that,
And
so.
since I kind of started this all, and I do have a son with cerebral palsy, I mean, it's been 2 years, he's now 10, but they do have to get on the bus and off every day, and a van does pick them up, and the cars just go right by because it doesn't have the thing that goes down, the stop sign, the flashing lights. So it really is a safety issue, so thank you so much. I sincerely appreciate it.
And just so you know, the board does take these issues very seriously, and this is one that sits high on their priority list. Thanks.
Thank you.
Hi, Sarah Armstrong, Radnor resident, and I've been working with Kimmy on some of this traffic issue. I was told, and I think some of us were told, that you can't put in stop signs for traffic calming measures. Is that correct or is that incorrect?
That's correct.
Okay, so maybe stop signs won't work.
Stop signs, if they meet the warrants, they can, and they have met the
Okay.
warrant, they have met
I
the
like the idea of
warrants in
stop
these.
signs. I just want to make sure we,
No,
2 of
what
them
the
met
manager said
warrants,
is
the other one
correct.
they're looking into.
okay.
If they meet the warrants, then they can go in.
That's correct.
It's more
Commissioner Haynes, you see-
complicated
oh,
than
okay.
that generalized statement. We have
Okay,
stop
fair
signs
enough.
all over Radnor Township that, if we had a clean slate today, couldn't meet that requirement.
Okay.
But as Chief Colarulo has noted, there are other factors. Are sight lines.
Yep.
Can a person safely come out of a side street and get onto the arterial road? Or must he or she push into the arterial road before
Yep.
she knows that it's safe? And we had that on West Avenue, and as a result, I think we were short on the warrants on West Avenue and Eagle Road, yet we went ahead. So to say that because we don't meet, you can't use stop signs to control speed, isn't really the end of the story,
Okay, very good.
with all due respect.
Oh, no, I'm supportive of the idea of stop signs, but we had been told we couldn't have that to cut just as traffic calming.
I
but
think we can
if
work on that.
Okay,
I
I
really
like
do.
that idea. Thank you.
Okay, community development. Can I have a motion? Oh, who's community development? Don?
Yeah, I move the introduction of ordinance 2015-03, amending Chapter 170, Radnor Township Code, Food Regulations.
I'll second it.
All right, who's second? Raise your hand. All right, John's got it. Any commissioner comment? Public comment? All those in favor say aye. Aye. Passes 7-0. Public safety?
I'd like to move for the adoption of ordinance 2015-04 about stop intersections and adding a new stop intersection for Oakford Road, Arbordale Road, and Creek Drive.
Have a second?
Second.
Commissioner comment? Public comment? All those in favor?
Aye.
Passes 7-0.
Next, I'd like to move for the adoption of ordinance 2015-05, rescinding a handicapped parking space on David Drive.
Have a second?
Second.
Commissioner comment? Public comment? All those in favor say aye. Aye. Passes 7-0. Public Works and Engineering, Jim?
Yes, we have Resolution 2015-54 proposed preliminary approval of Villanova University's housing project, which I believe also includes, I know it also includes Performing Arts Center, retail shops, and a parking garage. And this has been before us a number of times. It's been before our Planning Commission a number of times, the Delaware County Planning Commission a number of times. So I think there's been a lot of discussion and debate. I know there are people here that want to speak about it. And so I think at this point,
I'm kind of fumbling here. Do we need to have the applicant
Now,
come
the
up?
applicant's
or-
going to address the issues that were at the last, that everything is satisfied. And
all right.
what are the outstanding issues, and then we can discuss
All
them.
right, I'd like to note that I will not be participating in this conversation or vote because I have a conflict of interest.
I believe that most of the issues that we spoke about last time have been resolved in the review letters by the township professionals. There's two that remain, and I guess also just would like some clarification. I did speak to Steve. I believe Steve has two review letters that are subject to the resolution. The third review letter involves his status of the conditional use process. My understanding is that is not part of the resolution. John, just to...
Correct.
Okay. Because they have dates on these review letters, but they don't say how many or what they're in reference to. So my understanding is we have one review letter from Gannett Fleming, one review letter from Gilmore, and there's two review letters, I believe, one on Church Walk and one on the housing development from Ritu. And the only comments we have on any of those review letters are two comments from Steve Gabriel's Ritu letter, one regarding the sidewalk along Church Walk, which, again, I believe that we had discussed previously last time. And also, there was a comment from Steve regarding rezoning of a small strip that is zoned R3 that is currently used for parking. And as to the first one, the driveway going up to Church Walk, that would only be open really for funerals and weddings. It's not really a pedestrian-type access way. And so that's the reason we don't feel it's necessary to put a sidewalk there. There's not a sidewalk there currently. The use would be no different than what it currently is as far as being used for church functions. As to the comment regarding zoning, again, it's just a matter of clarification. I think that the Ritu letter kind of recommends that it be rezoned, but we just don't want it as a condition of the approval process. So we were asking that it be removed. We would have no objection at all to it being rezoned, but we just don't want it as a condition because if it's not rezoned, then there would be problems with development. So there are the only two comments regarding the review letters. And the other comment...
Excuse me, Nick, can you identify
yes.
where they are in the letters?
Yes. On the Ritu letters, it's the Church Walk letter, and it says Church Walk, I believe it's dated May 4th, 2015. Church Walk letter, review number 2. It's on page 2, and it says subdivision comment 2.
And that's on the sidewalk?
That's on the sidewalk.
Well, that was discussed at length, and the commissioner said it was okay not to put a sidewalk there.
And the second comment was on a different letter from Ritu, again dated May 4th. It's on page 3, and it's the Lancaster Avenue housing letter, and that's the comment that he says a portion of the subject site is zoned R3 and should be rezoned to PI plan institutional. As I said, we would have no objection to that, but we just don't feel it should be a condition of any approval. And so they were the only two comments. Again, Church Walk review letter, it says review number 2, page 2, subdivision comment number 2. And then also the Lancaster Avenue housing letter, review number 3. And it's on page 3, and it says specific zoning comment number 7.
I don't have that one. Just tell us what parcel we're talking about.
It's where the current parking lot is, the current Pike parking lot where the housing development would be. I had hoped that this was going to be presented to the board ahead of time. I believe it may not have been. If I can hand a copy up.
What is it?
It's just showing the corrections and where it's referenced.
So I have a feeling that there are going to be people who will object to that. And to me, that's how I would have liked this to have been done, that would have come to us in advance. But I have a feeling that some will object to that. So no offense, Nick, that might be a great idea, but my sense is that some would object to the fact that they didn't have an opportunity and won't have it before them. I don't know if others feel differently, but that's something for us we've come a long way, so that's something for us to consider right now.
This was presented well in advance, but again, I'll defer to what the board thinks. As I mentioned verbally what the two comments were.
If those are the only two, my sense is that we can resolve those two without further submissions to the board at this point. I don't know if others feel differently.
Yeah, I'm fine with it. Just where was the rezoning
It
piece?
was on,
Is that Ritu's letter?
it was Ritu's letter. It's the letter that's titled Lancaster Avenue Housing Letter.
It's dated May 4th.
May 4th, okay.
2015. There's two Ritu letters attached to the resolution.
Right.
This is the second one, and if you go to page 3, paragraph 7 says, and this is a comment from Ritu.
Okay.
They reference the Delaware County Planning Commission letter of February 19th, 2015, and the portion of the site which is currently in the R3 zoning district has parking on it. And the county recommended that that be rezoned to PI. My view has always been, and this has been discussed, that that is parking, that's remaining parking. There's no reason to rezone that. It's an existing non-conforming parking area. So I think what I'm hearing from Mr. Caniglia is that although they would like to have it rezoned PI, so it's consistent with the rest of Villanova's holdings, there's no need to do it, and they just don't want to have that attached as a condition. So the board's in agreement with that. That just, I would modify the resolution. I would edit the resolution that you finally vote on and remove that as a condition to the extent that it's in this letter. And it's the same issue with the sidewalk. There's a second Ritu letter, also dated May 4th, Church Walk and Bridge. It's, and on the second page of that letter, the reference in paragraph 2 to the sidewalk on the north side of Lancaster Avenue. I guess, Mr. Cornelia, Villanova's position is that a walkway is not necessary there.
No, the board discussed this at length, and we decided that a walkway was not necessary because no one's going to use it.
But I think what the concern here is that the resolution ought to reflect that.
We're going to remove those two items at the proper time then, unless there's an objection. Fine. What else do you have, Nick?
Okay, and then the only other comment as to the review letters is the comment regarding the park and rec fee. And you'll recall that we went through a PowerPoint presentation last meeting regarding the park and rec fee and pointed out in detail how the language refers to building area, which in any type of zoning matters is always referred to as building footprint. And I point out building footprint. And again, you know, I can go through that argument again if the board wishes.
No, we don't.
But it was presented last time in a good bit of detail regarding it. And, you know, so I'll just rely on those facts for now unless the board requires more.
Nick, refresh my memory on something. As part of that argument and those calculations, wasn't the dorms calculated as if it was commercial rather than residential?
The dorms were calculated as, I believe, it is calculated as institutional in the code. I have to look at the code and grab out the language from the code. But the ordinance talks about residential development, and it talks about residential development meaning basically single family or multiple family residential development, and then it talks about commercial development. So in effect, yes, it was being treated as commercial/institutional type development.
But we didn't acknowledge institutional when we wrote that.
No, in the ordinance, it's not acknowledged whether it's institutional or anything of that nature. And as I mentioned, you know, when you talk about building area, and that's the whole argument, is building area really relates to footprint. It doesn't relate to, you know, gross square footage. And we went through an analysis as to why it's not related to gross square footage.
And do the calculations include the Performing Arts Center and the garage?
It includes the Performing Arts Center. Our calculations did not include the garage because the garage itself is not a building, and the garage doesn't add to any park and rec demand that could possibly be added to. So that is why we excluded the garage.
All right, I mean, it's my opinion that the ordinance is clear, that the building area is what's on the land. It's not the total square footage of the building. If we wanted to do that, we should have put total square footage of the building. So I think we should calculate the building area as the area that is on the land. That calculation, without the garage, is $130-some thousand. How does the board feel about the garage? I don't think that's a building, but what do the other members feel?
Well, the garage is a structure. Hold on, the garage is a structure, and I think if we start splitting hairs here, it's kind of silly to me. This is a structure. Okay, yes, it's, what else is it? There's no other word for it. So therefore, the square footage should count.
Does it say structure or does it say building? Is it a building?
Well, the word building and structure is synonymous.
Can we let John talk?
The argument has been gross floor area, which is 497,000 square feet, which is, we put the gross floor area in the resolution, which is the maximum, or is it building area? The way the ordinance, the subdivision ordinance provision that the board adopted a couple years ago to assess a park and rec fee has two components. It has a residential component, which basically says that for all residential subdivisions or land developments of 4 or more lots or dwelling units gets assessed the fee, $3,307 per dwelling unit. The non-residential part of the ordinance says for all non-residential subdivisions or land development, the amount of land to be dedicated, because remember, this is either you dedicate land or you pay the fee. And it's really it's the landowner's option to some extent, and they have to agree to the fee. So under that, it becomes a calculation of building area or gross floor area, dividing that by 4,000 square feet and multiplying that by $3,307. So I hear Mr. Cornelia tonight saying that the garage shouldn't count. I disagree with that. I think that's a building area. It doesn't say by building, it says building area. I know they don't want to pay the gross floor area, and our ordinance doesn't say gross floor area. But the building area would include the dorms, the performance center, and the garages. And this is going to come up again with biomed.
So John, it's my understanding that you or staff has calculated a fee that would be associated with the interpretation that you just provided?
Roger had done a calculation last week of the garage, the dorms, and all the building area on the site. And the fee is approximately, subject to that, assuming the board accepts building area as we're defining it, that there may be some variation, but that's about $175,000.
And how much is it?
About $175,000.
Okay.
And maybe to Don's point is we differ in that, respectfully differ.
Yes.
In that calculation between what John has and what administration has.
And I think we're going to resolve that tonight.
correct,
And the
sure.
what we decide tonight is going to be policy going forward, correct?
Absolutely, sure.
So John Rice, my sense is that if that exact number is available, that exact number goes into the resolution. If the number associated with your interpretation is not available, then we have to decide what to do. But it's my understanding you've provided that number.
Yeah,
what is the exact number, John?
the number is 100. The fee after you apply the square footage is $174,408.
All right. Well, I would
And that includes the garage, and that's based on the calculation that Roger had put together last week, and I think the board has that.
I think we should include the garage. I think that's point number one. Secondly, whatever happens tonight, remember, we have the ability, the power to amend our code so that if we don't like the way something is being interpreted by developers down the road, we can change it. We can move quickly on that point, on that process.
Since this fee has to be accepted by Villanova, I would ask Villanova to accept the $174,400. Do you accept that?
Hang on, the board hasn't agreed on that number yet.
Well, I want to make
So-
sure that the Villanova agrees
Well,
on it.
let me just ask, John, what was the multiple for residential? How many dollars per residential unit?
I just want to make it clear, it is not a residential unit under the definition of residential unit under our zoning code or saldo or anything of that nature.
So the students won't,
No,
so you're
that's
saying the
not-
dormitories aren't
John,
considered
that's what I'm saying,
residential?
under definition of residential unit.
So John.
The definition of dwelling unit in our zoning code refers to single-family dwellings. Dormitories are a different type of unit. They're specifically excluded from the definition of dwelling unit. A dormitory is a separate entity. It's
Okay,
not
so
a
John Rice, do you agree with that? Nick just stated that dormitory is not considered a dwelling unit in our code.
I agree with that.
Okay.
Yes.
Well, is it considered?
This is an institutional use with residential components, with office components. It's not your typical dwelling unit. And when this provision of the MPC was enacted, it's probably about 15 years old. It was really designed to deal with residential subdivisions and setting aside parkland in areas that, and giving the developer an option. Either give us land or pay a fee, and then there's some restrictions on the money that gets paid also. And the other operative part of that provision is that there's got to be an agreement by the developer to the payment or the land, one way or another. This is not something we can necessarily impose on any landowner, but I think it's fair to calculate the building area, including the garages.
So if we could calculate it as residential, just so the public knows, it would be about 1.75 million in fees. So I just want to make sure we quantify that. So when we're worried about 175,000, 400,000, if it was residential, if we had our code written in such a way that it was residential, and it is in fact residential because the students are going to be living there, the fee would be 1.75 million. So I just want to clarify that. I did the math. So I'm not in favor of discounting this fee in any way. I prefer that we treat it.
Turn on your mic.
I prefer that we treat this as the entire square footage of the unit. Yeah, I know that's counter to the solicitor's opinion and the representative of the applicant. I think in this case, because students have a pretty big impact on the community and the use of our fields and parks, we should stick to the higher number.
Also, I guess, John, under the CICD, there's no variation. Yeah, so the issue is, you're saying that these dormitories, 1,145 beds, are not residential units for purposes of the fee, either under the existing subdivision and land development ordinance or the CICD, and that it's consistent with our intent with respect to this fee.
Correct. This is a...
So this is not a dwelling, it's not residential? It is residential, John.
There are students living there. This is not your typical residential development. This is not a residential zoning district that we're talking about.
Wouldn't you agree, Counselor, that residential should include kind of uses like this? Because this is a residence, and if it's residential and it's a fee for parks, these are definitely residential units, irrespective of whether they are single-family homes. Wouldn't you agree?
I agree we should revisit the ordinance and clarify how the fee is going to be applied going forward. But with what we have on the books and my understanding of the legislation when this was adopted by the state 15 years ago, this is not the type of residential dwelling unit that the fee typically gets applied against. I've looked at other municipalities, Commissioner Booker, and since I'm the one that has to defend this, and they have to agree, I want to make sure that we're on a solid legal basis before you assess this fee.
Well, it's a big difference in the fee. I think it's at least $411,000 or 497 based on 497,000 square feet. Or Commissioner Fisher just said it was $1.7 million if it was residential. So We're talking about we're talking about 1/10, or 10% of it, 1.7 million.
And that number I put out was based on 2 students per room, not 1. So, if you go 1, I don't know how many rooms there will be. I haven't seen the design. So.
Mr. Chairman, if I may just ask a question, and this would be to Nick and to Villanova, if they'd be willing to hold this until final approval? Because the only question it has, and I've heard this discussion, the U.S. Census Bureau takes these college students and classifies them as residents of Radnor Township. So to me, if we are calling that, and the U.S. Census Bureau counts them as residents within this
We
community.
have 2 opinions from our solicitor. Our solicitor said they're not residents of zoning, but he's also saying that under the state law, we might not be able to charge them this fee. So-
And that would be fine. I would just ask if they would
So,
consider
Nick,
that
are
in
there any
final.
other- Are there any other issues?
No.
Yeah, there's a couple other. So go ahead, Nick, but the second question is, you have to agree to the fee or to land, but you have to agree to one of them. It's not a choice, or you have to agree to it.
According to John, I have to agree to a fee. I've spoken to the applicant in the last couple minutes, and they would agree to the fee as being proposed by Mr. Rice, which would include building footprint, including the garage, as part of the building footprint.
Okay. Are there any other issues outstanding here?
That's the only issues. I do have Chris. I know that obviously, I assume at some point, if you wish, he would discuss the whole 1990 resolution, if you want to go
No,
there
well,
with
that's
it.
right. We'll deal
Even
with
though
that
it's
in a minute.
unrelated to this, totally unrelated.
We're going to have the
to this
solicitor
resolution.
deal with that, so he doesn't have to deal with it.
Oh, no, the board's going to deal with that, Bill.
Right.
Not
And-
just the solicitor.
and
The public
before-
wants to
and
deal with
before
it.
you leave, Nick.
That's right.
Yeah.
So,
Okay.
so what you're proposing, this resolution, and you would change two sections, paragraph 3 is what you're saying? That would exclude these 2 provisions from the RTU letters, or is there any other paragraph in this resolution?
No, everything else is acceptable to Villanova.
So it'd be paragraph 3 with the 2 exceptions related to the RTU letters, which is
Correct.
paragraph 7, and that would be the rezoning, and then the sidewalk on Church Walk.
Correct.
So those would be the exclusions from paragraph 3. And I would change this, it's really multiple correspondence, but I guess that picks it up. And then number 7, you're saying you would delete the dollar figure of $411,170, and we want to substitute it in, not the $1.7 million number, right, but $174,480?
Yeah.
I'm sorry, that number again is?
174,408, and what is the square footage? We'll change that number
So you
to.
don't need the square footage. And the square footage is embedded in the calculation, so at this point, my recommendation is to just put the amount of money.
Okay. All right.
Well, I think we need to have the square footage in
Okay.
there, because you won't be able to record it.
All right,
I guess, Don, your concern is that will hold up while we calculate that?
Yeah.
It's when you put the 174,408, you've defined the square footage, because it's a simple mathematic relationship of
Well, we know what the
multiplying
number
by
is.
3,337.
Let's put it in, I
What's the
think.
number?
It's worth it.
What's the number, Roger?
Roger has the square footage.
Roger, what's the number?
It's 210,957.
210,957 square feet.
Square feet, and that includes the garage.
Okay, thank you, thank you.
Thank you.
Public comment?
Well, so what about our 2
What's that?
waivers?
Well, that's
Well, do
for
you have
us
any
to-
questions on the waivers? The 22, the 22 feet.
Oh, there is, I believe, my understanding is actually that the second waiver now, the applicant has agreed to do a 30-foot curb radius rather than the 25 that was initially proposed, and the ordinance says 35. So the applicant's willing to do a 30-foot curb radius, and I believe that has been discussed with both Gilmore and Gannett Fleming as well.
Okay. And Commissioner, have questions on those? Public?
Whoa, I have a lot of questions.
So that waiver is being withdrawn? Nick?
No, it goes to 30
instead of
feet.
35.
I think you may
Fisher.
actually already have that in there, John, yeah, I think the
Excuse me,
30's
John
already in
Fisher.
there. That's
My sense
modified
is
from
that we're
last
going to
time.
go through and talk about these
Okay,
line
yeah,
by
I
line,
can
so
wait, yeah.
that would be my
But
sense at the time.
I'll just put it out there that I just want to remind everyone in the room that PennDOT, in their letter, specifically stated that they would like to see a 35-foot radius on that corner if there's no right turn lane. Now, tonight I'll be asking for the turn lane and for a 35-foot radius as well, but the point, and lots of other things I'll be asking for. But the point is, I just want to say one more time, our traffic engineer said it, PennDOT said it, the staff police, traffic, is asking for a turn lane. They're asking for the higher radius. Everyone's asking for it.
No, the traffic engineers actually modified it to 30 feet, John. It's in the packet.
He's on the turn lane.
Well, I'm on the turn lane.
The radius.
But, well, that's fine.
Different issue.
The point was, the original opinion of our staff engineer was that it should be 35 feet. PennDOT has already opined it should be 35 feet. So we're going to make a political decision tonight. If we don't go with 35 feet, it becomes a political decision.
No, it's a governmental decision, John.
It's a political decision.
Governmental.
And I prefer that we stick to engineering, not politics.
Let's hear from the public. Members of the public,
You guys don't want to talk first?
we're going to talk after you give us.
We're going to talk after you do.
Oh, okay, got it. All right.
Do we need the engineers, that we need Mr. Tweedy or any other folks?
No.
Why?
Where's Amy Kaminsky tonight?
Damon Drummond, Commissioner Fisher, Damon Drummond's here in her
Damon,
place.
too. Okay.
Good evening. My name is Christina Peroni, and I live in Wayne. Just starting on this one first issue. Oh, we don't need this up yet, but thank you. Starting on this first issue of what is a residence, let's step back and listen to what happened, sort of our history. Mr. Rice pre-negotiated the CICD in private, and you guys then came out and decided what you were going to vote on, what you weren't. Mr. Rice now is talking about a situation of $1.4 million. He's not sure that he can defend that in court. Well, don't you think we should have taken the time to figure that out, figure out the case law, whatever his hourly rate is, if we invest $2,000 to figure out if we can get $1.7 million, isn't that worthwhile? And to have Mr. Spingler just go and say, oh, well, he already said it's fine. It's not fine. It's $1.7 million. We have been very kind to this applicant. To have this applicant also say that this is not the same land and what we have discovered about this underpass is unrelated means we aren't understanding what Ithan Avenue is and that it's part of this development. So I'm going to ask a little indulgence, please, because I was one of the people who spent 30 or 40 hours looking at minutes of meeting, taking out books. So I would just ask you to indulge me for a minute to walk through just the process of what the citizens found out. And I would appreciate the courtesy of that. So this all started when Mr. Fisher said, hey, Villanova was supposed to build an underpass. I had never heard that before, and we started Googling and looking up underpass and looking up Villanova, and found an article which was then picked up in the paper that said there was this underpass that was planned. We then, thank you to Mr. Zinkowski and many other people in the township, they opened the books for us, and they were unbelievably cooperative and put out the minutes, put out resolutions, and we looked through 15 to 20 years of documents. And what we found was this whole story started in 1989 when Villanova requested to have a zoning change from residential to planned institution because they wanted to do a large development. And there were a lot of residents that kept coming up and talking and saying they're concerned about encroachment into the community, they're concerned about institutions getting bigger. And this went back and forth, and if you read the letters and the notes and the minutes of the meeting, this went on for a very long time. As a result, Mr. Cornelia was the one who said, let's put this resolution, because he wanted, obviously, to be able to do this development and to appease the neighbors. And what happened was he then had this, which you all know now as 9004, which says best efforts. And there was a lot of conversation about what best efforts means. And as of 2 weeks ago, when you guys rightfully put this whole thing on hold so that we can do a little bit more research, we thought it ended at 9004 with best efforts. It did not end at 9004 with best efforts. What we then found is that Villanova had a long-term plan put into effect in 1990 where they said they planned to build a bridge. Then the Suburban and many other newspaper articles wrote repeatedly how Villanova promises to do this bridge. Then what happened was Mr. Cornelia, which, you know, it's almost laughable now to have the same players up, but Mr. Cornelia told the commissioners that in condition number 3, the date should be included. The resolution will be amended to include in condition number 3 that plans for a pedestrian bridge will be submitted by March 31st, 1992, and construction completed by December 31st, 1993. And that was for 13 acres of the Liberal Arts Center. This story continued. So it became, let's try really hard to do it, and then it became a, yes, we promise to do it. Again, what you don't see is all this same stuff of neighbors being concerned and upset and hiring lawyers. People hired lawyers, and that was what was, it was like the same story over and over again, saying we're concerned. You really don't have a right to take over residential property, but we will let that zoning and we will release our right if you promise to do this. So it was a commitment to the community. Then what happened was, you know, again, the Suburban wrote articles saying that this new development was then connected to the bridge. Then what happened, which was the most interesting part of the story, was that the commissioners at the time were looking with the staff and the township manager, and they realized together, and Villanova was being very cooperative with this process, and they realized that a bridge on Ithan Avenue was not a good plan because of the topography, because they'd have switchbacks, and because it just didn't make sense for compliance with ADA and other regulations. So what they then said, because at the same time they were allowed to do their building. So their building, it was 63-acre development and a 13-acre development. So they were doing all this construction. At the same time, they were trying to find the solution to Villanova, as we heard this sad story of people being killed there. Everyone was talking about, this is a dangerous place. Villanova got up and said, we're scared for this intersection. This is not dangerous. This is dangerous for our students. I believe we have Mr. Higgins was a commissioner at the time, and Mr. Spangler, all talking about the safety of this intersection. So it was not unknown. So then what happened was they continued with their construction. And then what happened was they just decided, okay, we're going to give you the CO because it was actually Commissioner Marks, who I didn't know, but Commissioner Marks said in one of the minutes that he wanted to be involved with every single meeting that happened regarding the underpass. So simultaneously, they're doing their development, and they still weren't working out how to do this yet. And they were trying, and they were really working hard. And Commissioner Marks said, I will attend every single meeting until we come to a resolution. And they did come to a resolution. They engineered and designed this beautiful underpass, and they specifically talked about it will not be scary. They said there will be lights. They raised it up. There would be plantings. There will be security cameras. They said this is not a tunnel. This is going to be a place, and the priests were talking too. This is going to be a safe access. We are going to do this beautiful, beautiful, and there was apparently, I think Commissioner Spangler reported that there was a beautiful picture of it, or a to-scale plan that was shown. I want to just ask people to just take a quick look. These were the plans, sealed, signed, delivered for this underpass. Did it confirm with the time? It didn't. But it seemed, in my humble opinion, that people were trying. And that's probably why the township gave the CO, because if you kept reading the minutes, everybody was trying to solve this problem. It wasn't confrontational. It was a cooperative work with the township and the community to try and figure out how to do this. And Villanova. Villanova worked really hard. The condition was not based on getting PennDOT approval. So we've heard that excuse, oh, they didn't get their PennDOT approval. It doesn't matter if they didn't get PennDOT money. It wasn't, the condition just said, I will build a bridge. So then what happened was the CO was issued, as Mr. Cornelia mentioned. The CO was issued, But this underpass continued. And then after the CO was issued and they allowed them to use the property, when in theory the township could have said, no, you can't. But the township, they were working as a team, which is fabulous. So then on November 27, 1995, they announced that the Villanova underpass would begin. Mr. Crawford was the one who made that announcement, and it was 4 months later, it was scheduled to start. PennDOT approved of it. Mr. Gallen, who was, I saw his name a lot. He was a senior person at Villanova. I'm sure the others can say exactly what his role was, that they were excited about this project and it was going to start. And there were all these letters in the newspaper that we found showing the underpass was to start. And then we found nothing. And then there was nothing. So, you know, this was us unearthing all these documents. We're not professionals. I'm just a citizen who cares about, doing the right thing. And I would just ask that you don't allow another condition to be put on this land. This land has a defect in it. This land has a condition, a pre-existing condition. And you should respect that pre-existing condition. Will this completely mess up Villanova? Absolutely. Will it cost them millions of dollars? Absolutely. But I bet Mr. Cornelian knows that he was supposed to build an underpass. We don't know what happened and why it ended. And I would ask other people to find that out because we couldn't see what happened. We never saw any more articles, and at some point your eyes start crossing when you're reading these old documents. So I would say do not let them go and build on this land that was already pre-committed. Please do the right thing and go and say, let's find out what happened. Make Villanova come up with where that resolution was that changed it. I didn't see it. There may be a resolution out there that says, forget about it, don't worry about the underpass. But I think it's unlikely because there were all these newspaper articles. So please, please do the right thing. Please don't allow, even though you've spent years, you did the CICD to give them new zoning, then they put in all of this work. They've spent millions and millions of dollars. But you know what? Last time there were millions and millions of dollars too, because there was meeting after meeting after meeting with our own staff and with people like me and lots of other people coming up and speaking and hiring their own lawyers. So the story is the same story. I just would ask you to please consider the honorable thing, and that is to respect what was done in the past, and they shouldn't get special rules. If I knew that my sidewalk was cracked and I was told that there was a hole in it and I didn't fix it and somebody fell in it, I would so be sued for that because I knew it was a pre-existing condition. Well, everyone knows it's a pre-existing condition. From 1990, people were killed there. And there was a solution of this underpass, and it wasn't ever done. So I think the township has liability, Villanova has liability, and why should we go into lawsuits? That's not fair to the community. It's not fair to the taxpayers to make them hire a lawyer to fight this. That's not right.
Thank you very much.
It's just not right. Thank you for the time.
Is there a drawing, like a site plan?
This is the drawing, but it's all just detailed plans. It's all, there's not a pretty picture of it. It's all just.
No, I'm sorry. Thank you.
No, it's a fully engineered design
But there's
of.
nothing pretty that would show it to you.
It's a fully. I came in this last week to look at it. It's a fully engineered plan for an underpass, pedestrian underpass. I wouldn't call it a tunnel. It's more of a concourse type thing, underground. And Jim, this was, I think I just want to say something while it's fresh in my mind. I think what's really true here is that there was a good faith effort between Villanova University and the township to build this underpass. I see it. I see it in the documents, but you know what I see? I see a lot of turnover in staff in the mid to late 90s. And then, sadly, I see Bob Crawford dying of cancer. And the people that needed to steer it from this side were no longer here, okay? The elected officials changed, okay? But let me just say this.
We're on public comment.
But in the end, Villanova still has an obligation. It's still a legal obligation. I don't care what the legal opinions are. This is a legal agreement that was entered into by two parties. One party had turnover and death. The other party's still there, still viable, still able to do this, still should be doing this.
John, this isn't
and
the
they haven't
United
done
States
it.
Senate. We're not filibustering. It's public comment.
Yeah, it's not a filibuster bill, but you and Jim should know better
I know.
of what went on.
Any other
then.
public comment?
Jane Galley, 7th Ward, Barclayton Road. I, too, was looking through documents. I came across the traffic plan done by the Villanova's own engineer. Interestingly enough, they talk about if I could have a little help here, they talk about the parking as it exists today, where people park and what people do, students do, in these parking areas. Where do I need to go with this? There we go. And interestingly enough, Pike Field, Pike parking lot and the main parking lot, they say the students go and cross at this corner. Then they show the students from South Campus, how they get to school. And a portion of them go across the bridge, across the P&W bridge, and then across to the school. A whole load of them, which if anybody's ever driven there during class passage time, cross at Ithan and Lancaster. I am supporting what Christina just said. What's interesting to me and what I am amazed about, that no one thinks that placing a parking lot here for 1,230.
You got to stay near the mic. Pull the mic towards you.
I'm sorry. It's interesting to me that a parking lot being put up with over 1,200 parking places, Villanova's trying to tell us that those students are going to get out of their cars, they're going to walk all the way down here to Church Crossing, to the church bridge, go back, and either they're going to be going to the business school, the nursing school, the athletic area, they're going to walk all the way down and then walk all the way back. Anybody who has a kid will know that's not going to happen. We're going to have, and then you're going to have a bunch of residents who are all here, even though they're not residents, in their dorms, that who will end up walking across that same intersection. This intersection is a disaster waiting to happen, and I ask this board to use your own common sense to know that the tunnel, which was promised over 25 years ago, or the bridge, or something, does not belong at Church Walk. It belongs at Ithan and Lancaster Avenue. So I ask you, please, to keep that in your consideration. And the other point, which I've now lost, but I'll think of it in a moment. Anyway, oh, yes. Aside from the pub tunnel and everything else, a quick thing. Where are all the students parking during all this construction? That's just want to know. Where are they going to be? Where are all those people that park in that big lot and the side lot? Where are they going? Just FYI. Thank you.
Thank you.
One more page.
Oh, sorry.
You know, there's a saying in college admissions offices that the bigger the file, the weaker the candidate, i.e. they're trying too hard to fit where they don't really fit. And I think this is about the biggest file that you've ever had here in Radnor Township. Oh, I'm sorry, Jim Yiannopoulos, 15 Braxton Road. I forgot that part, but I guess everybody up here at least knows me. We had a meeting with PennDOT a month ago, and at that time I kind of innocently expressed concern that, gee, maybe this bridge is in the wrong place. Won't the 50% of the students who live closer to Ithan and Lancaster take the easiest route, and that's Ithan and Lancaster? The response I was given then by Mr. Tavani was that 70% of the classrooms are closer to the proposed bridge. I thought about that later on, and the first thing is I can't find any indications that measurements and data were taken to actually back that claim, but even if it is true, you know, again, as the previous speakers have said, we need a little common sense here. It's really unrealistic to assume that every student gets up out of bed in the morning and goes straight to class, so that 70% of them are going to use the bridge where it's currently proposed. Some of them will, but some will get breakfast. Admittedly, a minority of college students will do that, but they'll at least get coffee and a bagel first. And the locations for obtaining all of those are closer to the intersection of Lancaster and Ithan. And in the afternoon, are they going to return right from class back over that proposed bridge, back to their rooms? No. They're going to go to lunch, go to sports practices, work out at the fitness center, and all those locations are closer to the intersection of Lancaster and Ithan. So I've concluded that the proposed bridge in this proposed resolution is in the wrong location. 70 to 80% of the students will use the crosswalk at Lancaster and Ithan. I don't see how they're going to be motivated to go way out of their way to use the pedestrian bridge at a location where it is currently proposed. So now we've learned that, gee, over 20 years ago, that's where a bridge or underpass was supposed to be. And we've learned that there was actually a resolution that was passed that included the condition and a certificate of occupancy was issued based on that condition. I'm asking you to do the right thing. We're talking about lives here. We're talking about an intersection that was considered dangerous then, and we're talking about 1,150 additional students making that crossing perhaps 3 times a day. So I'm asking you to do the right thing by them, by the students, by those of us who are scared to death we're going to run some student over at 11:30 at night when they cross against the red light and we don't see them. So I think what you really need to do if you're doing the right thing is consider what was agreed to, admittedly by a previous board, but it's still legal. It's still required. And at this point, the bridge or the underpass isn't there. So I don't see why they have the certificate of occupancy, and I don't see why, if we're doing the right thing here, that certificate of occupancy isn't revoked until such time that they do the right thing. Thank you.
Thank you. Anyone else?
Good evening, Phil Lahr, Meredith Avenue and Garrett Hill. We have 2 things going on here. One is that you have a precondition that seemingly never was filled. So you seem to have a legal obligation that perhaps you're going to weigh in on, and speakers have asked you to do the right thing and make sure that happens. Curiously, the conditions that allowed and made for that tunnel to be there at that intersection have not changed. This is a decision that affects our ward, in Ward 7, the Township, and Villanova University in terms of safety as well as for traffic. And the fact is that you have 300 active daily use parking spaces that are going to be in that Pike lot. You have half the dorms who may go to class, go over the church walk, but will certainly go to the Connolly Center crossing Ithan Avenue. They'll go to the athletic facilities crossing Ithan Avenue because that's convenient. And that's what you would expect. And in fact, so much so that we've heard reasons not to include a right turn lane so far is because so many students will be crossing that lane that we have to preserve the shortest walk time we can. So I'm confused. All these numbers are conflicting. The biggest point is that the safety concerns, the accidents that have happened, the potential for danger will not be reduced 1 iota by any of this that we've so far seen, except by building an overpass or an underpass at Ithan Avenue. It's a critical juncture. So we ask that you consider that. This is our chance now. You're never going to face this again in another 100 years. And yet the problems that we have will be there. It may be expensive. You know what? Maybe there's a grant out there. The first step is not to accept that our hands are tied. They're not. And once you accept that, let's find out how we can get to the best solution. Because frankly, if there's an underpass in there, 80% of the problems of this whole development go away, and the rest of it sails through. It's an interesting solution. Thank you.
Hi, good evening. Matt Marshall. I live at 228 Walnut Avenue, Wayne. This approval, although it's taken a long time to get to where it is, it does not seem like it's ready for this board. And just a couple of things. A binding agreement 20 years ago, if it was conditional on having a certificate of occupancy, somebody, probably the solicitor, should give you all an opinion as to why the applicant wasn't required to complete the tunnel. And then secondly, I think probably the more current issue would be the Parks and Rec fee. I mean, you're looking at essentially a 10% contribution of what this board could potentially be looking at in terms of revenue. And having a decision tonight will therefore become the precedent for every other applicant that comes before this board. How could you possibly make a decision with a 90% variance between what the township taxpayers would be entitled to under this ordinance and what you consider to be the calculation? It doesn't make sense. I think at some point those two questions need to be answered before you approve this application. Thank you.
Anyone else?
Good evening, Board. My name is Luke Clark. I'm over in the 3rd Ward on Midland Circle. Not on behalf of the Parks and Rec Board, but as a member of the Parks and Rec Board, this Parks and Rec fee I see as an opportunity that I hope we take advantage of. $300,000 or so could do a lot for parks that currently are scheduled for maintenance about 4 years out or so. The commissioners here have been in on those meetings, and we have a budget that we have to deal with, and I understand that, but this is an opportunity to bring these parks help now, parks that people use, and parks to make this township great. So if you can, if you would find in favor of the way the ordinance, I believe, should be interpreted and the way the staff should be interpreted, I would appreciate it. Thank you.
Tony Bailey, Conestoga Village. I believe Villanova, as an Augustinian university that is trying to position itself to compete with the larger and more prominent institutions of higher learning, that Villanova should do due diligence, act like them to ensure the safety of the students and the community. I believe that it's my opinion, before anything is finalized tonight, that all necessary analyses should be performed, reviewed, and analyzed. Thank you.
Good evening again. I'm still Sigmund Fleck, and I still represent my client. As I told you earlier, I understand that the solicitor will be addressing the issue with respect to the issuance of the certificate of occupancy and its effect, perhaps, on this situation. I've heard that through comments, I think, from Mr. Spengler earlier this evening. My question and concern is that after we hear from the solicitor, will there be further comment permitted in response to whatever comments the solicitor makes?
Sure.
Thank you.
All right, John, do you want to address that issue?
Well, let me just say at the outset, I'm not here to defend what the township did in the past. Typically, what happens with a condition on an approval resolution is that there's no permits issued until plans are prepared and money set aside to build the improvements. I don't know why that didn't happen in 1990. I don't know why that didn't happen in 1993. I do know that the township had a long-standing policy from the early 90s until 2006 that they rarely took financial security for a lot of the projects. And I think that that is part of what happened here. Since 2006, there's been no developments approved in this township, no plans recorded, no permits issued, no COs until there's development agreements signed and there's financial security set aside. And it's obvious to me that this didn't happen back in 1990, 1993. So I can't defend that. That is not the normal way that I know development is supposed to work. And I've been doing this since 1986. And in 1986, we always got financial security. We always got record plans recorded, and no permits were issued. Nobody got to start construction until all those I's were dotted and T's were crossed. So we're stuck with 20 years of, to some extent, well, to a large extent, inaction. I really don't want to address the tunnel issue because that's not on any resolution anywhere as a condition. I know there was a lot of activity and there were plans prepared, but I have the 3 resolutions from 1990, 1993, and there's no mention of a tunnel. There's a mention of the pedestrian bridge. So if we're talking about that condition, and is that condition enforceable today? We've got a problem. Trying to enforce a condition, a permit that was issued, and in my view, issued in error back in 1993. But when 20 years goes by, and there's plenty of case law on this, we have a couple attorneys in the room, they should all be aware of this, that when conditions don't get enforced over a 20-year time period, either through ignorance, inaction, lack of action, it results in the landowner essentially getting a vested right, and that condition goes away. There's plenty of legal authority for those types of activities. Municipalities issue permits all the time in error and find out about it 20 years later. If the landowner spends money in reliance on that, then municipalities are stopped from enforcing what should have been enforced at the time that the permit was issued. This is a similar, although odd situation in my view. I've never seen that kind of a substantial building project and an improvement, a public improvement, not A, financial secured at the time of the approval, and B, built without some other further action. There was obviously no further action by the board, but we've got a problem with enforcing that, in my opinion. When you have that much time go by and the landowner relies on it, the township relies on it, we issued permits. When we issue certificates of occupancy for all this construction that was approved in 1990, 1993, in my view, that operates basically as a waiver of that pedestrian bridge condition. Even though there's no formal action by the board to modify it or take it away. So there's plenty of case law on those types of situations. This is extremely unusual in my view. I can't defend it. And I'm really talking about the pedestrian bridge because I know the underpass sounds like it was a much better proposal and the staff in Villanova was working on it. No one in this room knows why it didn't get built, but it didn't get built. So, but that's not in any resolution anywhere. The pedestrian bridge is, it should have happened. The ball got dropped. The problem is the passage of time then, to some extent, washes that condition away. And there's no basis. You got a new plan in front of you tonight. And the only way you can deny a plan is if there's some ordinance or law inconsistency that you can base a denial on. The failure of that condition, in my view, would not fall within that as a reason to deny this plan. You know, I wish I could say that you could force Villanova to build the underpass, but I can't. It's not something that's enforceable at this point. When you have a situation like this, there's passage of time, parties rely on it, and the municipality, through inaction, whether deliberately or just because of change in staff. John, you mentioned, various people left the township by different reasons. Someone did not follow through with it, and it would be very difficult to make a strong legal argument to any court that this board would be able to force that at this date.
John, I just want to stress, though, that during the time the CO was issued, there was clearly a good faith effort between the university and the administration. And that good faith effort was what was traded for that CO. The fact was that Villanova was actively designing, engineering a solution for that site. And we didn't just give them a CO because we trusted them. They were acting. They were acting in good faith in the direction of the original resolution. Now, bridge, tunnel, the point was...
Where was the financial security, though, to guarantee?
Well, there was...
The only thing that counts is that money talks, and any landowner, developer, whether it's a university or a builder, if they don't put money up to build that, then the municipality is out on a limb.
And that's why tonight I will be asking Villanova to pledge full escrow for the construction of the bridge at Church Walk. The full amount, nothing less than the full amount. The point is that if they default on construction of this other, I'll keep calling it the other bridge, because I think they owe us 2 bridges, but the point is, we're not going to let this happen again, and I'm going to still ask Villanova to construct a tunnel or a bridge at Ithan. They have an obligation to the public. Forget the board. The point, it was really well said. It was argued at the time of those approvals in 1990 and 93. This was a contract between Villanova and the public. The public acquiesced. They stood down. They got what they wanted. They got the bridge. They got the bridge, but they didn't get the bridge. Okay, Villanova still had an obligation. Their attorney at the time, fully well knowing what the obligation was, continued along, but didn't mention it. Okay, the people. It's very interesting to me. The people that were in the room then, some of them are in the room now, and yet they don't treat obligation the way I treat obligation. And the people in the public expect obligations to be filled. So
you and I have talked about this.
Yeah.
You know that in terms of development agreements, which lay out the developer's obligate, once the board approves this, there's a condition in this resolution that says there will have to be development and financial security agreements executed to the satisfaction of the township solicitor. So that, and the engineering department and myself and the staff guarantee that we have financial security for all the improvements. Agreements get signed, they get recorded. We do a memorandum of our development agreements, and they get recorded, so it's an obligation against the land. That never happened prior to 2006.
Excuse me, I just need to, can I just tell you there was escrow?
Christine, you'll get a chance to speak.
There was escrow, there's documentation.
Christine, it's not your turn yet.
Well, Christine is trying to.
I'm just trying to.
Christine, wait till I call him.
Valid
Okay,
information.
I was
John, you are aware there was an escrow.
I was told that, and I know it doesn't
Christine,
exist
can you go to
anymore.
your seat, please, until we call you? Thank you.
Well, doesn't exist. The point was there was a developmental agreement signed. There was an escrow amount paid, and the point was that we don't have accounting of that at our fingertips. It may be found. John hasn't had time to review it. Up in Bob's side office, there is a huge amount of data and information to look at. The point is that obviously there was escrow money given to the township, but the point was not the millions that we needed to build the tunnel.
So, I mean, my only point is that is, forget about the promises to use best efforts, the promises to do the right thing. If you don't have the agreements and the money and you don't hold on to it, because whatever got posted, I'm pretty sure it's not here anymore. Somehow it got released, maybe for some other improvements other than the tunnel. If you don't hold on to that and track that through, you don't have a guarantee you're going to get the improvements that are on a plan approval. And we don't do that anymore here. We have plenty of agreements on file here for all the projects that have been prepared. And that was a change in 2009.
Well, John, there's just one more thing that we're not going to do this again. Two things. One, although you keep stressing that there was detrimental reliance on the forbearance to require a bridge, I don't see it. There's no reliance on not having to do something. I just don't see that as a justifiable rationale. The condition existed, and as John pointed out, the condition existed, and people are here. I really would like to, at least there's people who know about this. The condition existed. The CO was given. Obviously, there was a gentleman's agreement. Here, take the CO. We trust this renowned organization, this religiously affiliated university. They say they're going to build it. We can trust them to follow through on their commitment to build an improvement that they said that they're going to build. We can give these people, we can trust Villanova to have a CO and then to still follow through with their obligation. I think based on, and I wasn't here in 1993, I didn't get here until 1999, but that seems to me the likely circumstance. And what we've also been shown, at least by Tish Long's counsel, is that the provision of a certificate of occupancy in no way relieves the condition that was precedent to that issuance. That obligation is part of the land. It's almost like an equitable servitude, right? It's something that was there that is a condition that's necessary. So we don't waive it by issuing a CO, especially when there was a gentleman's agreement and a trust that was there. So I'm missing the rationale, and it seems to me that this is a requirement that is still unmet and should be before any additional approvals are granted.
Any other commissioner comment?
Yeah, I have a couple of questions. John Rice, from what you just described, are you saying that there was an affirmative obligation to build a bridge at some point, or was the affirmative obligation to use best efforts?
Based on the liberal arts resolution, which was referenced earlier, there was a date set, 90-30, resolution 90-30. I mean, it was in the original 1990 resolution, 90-4, and then the same year it was carried over in this resolution that commitments, there were dates in here, that plans by 1992, construction by 1993.
Right, but
That's an affirmative
I interpreted that as
obligation.
still as best efforts, meaning that to me was part of the same best effort.
No,
provision.
Can I read this verbatim?
No,
I'll read this.
John, please, I have the floor. I'm allowed to ask questions, okay?
Don't interrupt them.
It's appropriate for me
Verbatim,
to...
please.
It's appropriate for me to ask. And quite frankly, he answered it, I heard him answer it the way that you probably wanted him to answer it. So
Yeah. That was an affirmative obligation
okay.
in here.
So your opinion is that they did have an affirmative obligation to build the bridge in the 90s?
Yes.
Very good, thank you.
Any other commissioner comment? Any public comment on this issue?
Thank you for letting me speak again, and I know that's not a normal situation. There was a document that said there was escrow being held. So we did see that document. I can't get my hands on it right now, but there was escrow. So Mr. Rice, I know, was on vacation, and I don't think anyone has had time to go through everything, but there was escrow held. So that argument is not, in fact, unless somebody can find out what happened to that escrow. And let's also remember that the township manager, Mr. Bayshore, who took over sadly when Mr. Crawford passed away, was then, although not convicted, we fired him for embezzling funds or lots of bad things. So we know he wasn't a good dude.
just in response to your solicitor's comments, I would say that while there may be a body of law that protects certain vested rights, there's also a doctrine of estoppel, which basically speaks to the cleanliness of one's hands when you come to court. And while there may have been unfortunate situations and the death of your township manager and turnover on staff that resulted in a loss of corporate continuance, a loss of the flow through your township, across the street, across Route 30, Villanova University remains. And in fact, they're still represented by the same council who was here and insisted that the dates referred to by your solicitor be inserted into that very resolution. So it is hard for me to fathom, and my firm is solicitor to numerous municipalities, and we also represent, in other municipalities, lots of developers. And we've never seen a situation where the issuance of a certificate of occupancy acts to relieve an applicant of a duly enacted resolution which has all the force and effect of law that this body passed. The university absolutely, in our view, would be stopped from even arguing that there is now a vested right in them to continue to violate the law as set forth by this body. And in any event, you have a new application in front of you, and for all the reasons you've heard this evening, this application should not be permitted to go forward without resolution of that Ithan Avenue bridge. Thank you.
Good evening, Chris Kowalski from Villanova University. I just wanted to add the voice of the university to this conversation. We've all, I think, learned a lot or tried to learn a lot about this project over the last couple of weeks. We are happy to make our materials available to the public, both here at the Township building and at Villanova University. I know at least 2 people availed themselves of coming to our office, and hopefully others looked at what we had here. And our documents revealed a lot of what you already heard today. But I think what I'm hearing from the conversation, from the comments made by the public and some of the commissioners, that this is a one-sided decision, that if it didn't happen, it means that Villanova walked away. And I don't necessarily think that's true. However, there's really nothing out there that says one way or another whether that's true or there's another possibility. But we reached out to 8 people who were involved in the project and whose names appear in the notes, whether they were architects or engineers, township officials, former employees of Villanova University, and there were different things that were remembered, including funding that did not appear from PennDOT, problems with the application process, different things that didn't necessarily weren't necessarily shared by many people. But the one thing that was shared was a tremendous amount of concern by both the neighbors and the township representatives, township itself, for the disruption that the tunnel would have caused to Lancaster Avenue. We know that it would have been a multi-year, 2-year construction process that would have closed at least 1, if not more, lanes over that period of time. The road would still have to be maintained while they were boring the tunnel under it. It would have brought traffic into the neighborhoods. There were minutes from neighborhood meetings. There were letters sent to the township, letters sent to PennDOT, all concerned about the disruptions that the construction process would cause. And so the best guess of everybody that we talked to, the best recollection, was that the combined troubles, traffic, annoyance, delays caused by the construction process meant that the tunnel was no longer desirable. And by mutual agreement, not in writing, not in any record, it went away among PennDOT, the township, and Villanova. Another thing that happened over the period of that time was that the way that the intersection operates was changed. During the course of when the conversation started until it died away, that all-red pedestrian scramble that we've talked about a lot over the past 4 years was installed. We believe that's when the fencing was installed around those main lots, and that's when left turn lanes were installed eastbound and westbound on Lancaster Avenue. So the result is the intersection operates differently. It's still very busy, but it operates differently and more safely, as the data and statistics outlined in the traffic impact study show. So I just wanted to add that. I wish I had a piece of paper that outlined that, but I wanted to add what we were able to find as a result of our investigation into this as well.
Jim Unopoulos, 15 Braxton Road. I heard Mr. Kowalski just say that it was, as best as they can discover, it was by mutual agreement. And we don't really know who the agreement was between, really. Who had the discussions. It was not done publicly. There's no public record of it. There is a public record of this resolution with this condition. In terms of what Mr. Rice said a few minutes ago, there's only one thing that I would disagree with, and he said that probably no one knows. I think at least one person in this room knows, and perhaps a couple of you on the board know. And if you do know more than you're telling, I say shame on you. Thank you.
Well, I would just like to say I reached out to Duncan Ubley, the township engineer at the time, and he said that he was in Bob Crawford's office, and Bob Crawford said we were not going to build the bridge any longer. It was too disruptive to the community after all the meetings. All that traffic would have down Lowry's Lane and Garrett Avenue, and I was on the board at the time. I just have a recollection that we weren't going to build it. Commissioner Marks, who wanted to be at every meeting, was at those. He never complained at any meetings that we weren't building the underpass. I never heard any commissioner complain about not building the underpass. But Duncan, the township engineer, said the only thing he remembers sitting in the manager's office and the manager tell him we're not going to build the underpass. So
where is the public documentation that that condition was removed from the resolution?
I don't remember voting on any resolution like
So
that.
the manager doesn't have the authority to strike law. That's why we're here. The public elect us to write the laws, create the laws.
Yeah.
And even our sitting manager, Zinkowski, doesn't have the authority to undermine
I understand that.
our
I just gave
activity.
the information, John.
So, no, I appreciate that, and I've heard the similar types of stories. But the bottom line was, Villanova has an obligation that's still outstanding to build a bridge at Ithan Avenue. Until this board acts to remove that obligation, it still stands.
I'd be interested in what Mr. Cornelia remembers. Do you have any recollection? You were counsel at the time.
Rich, basically, my recollection has been the same as been mentioned here by Chris, and my understanding from Duncan Hubley was the same, is that it was a township decision not to go forward, and they were talking about the underpass, not a bridge. That's my recollection of it. I remember inquiring about it back around that period of time because there's a number of resolutions passed at that time. There were certificates of occupancy granted at the time for West Campus. And what I was told at that time is that Villanova had used their best efforts and the township did not desire to proceed with the project.
Sarah Pilling, Garrett Avenue. I hear Mr. Kowalski say that the scramble came in and this has solved the problem. I don't like to drive west on Lancaster Pike because I know it can take as long as 45 minutes to get from Garrett Avenue. Actually, it's from Lowry's Lane because I don't take a left out of Garrett onto Lancaster. That happens to be illegal. But I get up to the corner of Ithan and Lancaster, and the kids know that although the scramble is 23 seconds, on more occasions than I can count, at 4 seconds before it ends, they step off the curb to slowly walk across the street because they know we're not going to run them down. So the 23-second scramble really isn't the answer because what the university can't control is the kids' behavior. And if they want to walk across the street with only 4 seconds left, they feel pretty infallible that we're not going to willingly run them down. But I see these kids when I have to go that way, they don't even wait for the light. They'll cross in the middle of the block, run. And if it's dark, you're right. They are very vulnerable to being hit. And dear God, I don't want to be the one to hit them. So I don't think a 23-second scramble is the answer. What I'd like to see you do is what John has put up, is full escrow for this bridge comes in up front. And then we know it will be built because the money will be there. Thank you.
Thank you. All right, I would like to make a motion to approve this resolution, changing item number 7 to $174,408 and the square footage to 210,957, and to delete the two items on the sidewalk and the changing of the zoning. Do I have a second for that motion?
I'd like to amend the
Well,
motion.
let's put it on the table first. Can I have a
Second.
Second on the motion. Okay, Commissioner, discussion.
All right. Still a number of items I believe are outstanding. Give me a second here.
I got two. If you're ready, I can go with.
Yeah, I'm ready. So, so the first item is I asked the applicant, I guess it's 3 or 4 weeks ago now, to come prepared to the preliminary approval, prepared to discuss the idea of a cap in enrollment. So the entire process that we've been through for the last 3 years has been that it's been put forth that there will be no increase in enrollment. That's not the reason for the new dorms. There'll be no increase in enrollment. The residents are concerned about this. You know, we're talking about promises tonight, right? A lot about promises. So I'm asking Villanova to make part of this resolution to put that promise in writing that there will be no increase in enrollment. They've said many times, we do not plan to increase enrollment. They're using those terms, we do not plan to increase enrollment. That's not the same thing as saying we will not increase enrollment. I'm asking Villanova University right now to consider a cap in enrollment as part of this approval. So my motion is that Villanova University agree to capping their full-time and undergraduate enrollment as it is now.
Second.
Commissioner comment? Public comment? All those in favor, say aye.
Aye.
Opposed? Opposed. Passes. It's defeated.
Okay, the next one, since we're not getting a tunnel or a bridge at Ithan at this point, and we have been waiting for a long time for that, I ask for a right turn lane. So I'd like to amend the resolution to include a right turn lane eastbound on Lancaster Avenue onto Ithan Avenue.
Is there a second to that motion?
There's a second.
Commissioner comment?
Yeah, all right, so if we put in the right-hand turn lane, what about the radius? What's the radius?
Well, let's vote on the right-hand turn lane, then we'll worry about that. All right?
Well, no, let's talk.
Well, the radius should be 35 feet, as PennDOT stated.
So 35 feet?
Although, actually, PennDOT did opine that if a right turn lane was employed, that a shorter radius could be used. So I don't really have the answer to that.
Well,
but
the motion is to put a right-hand turn lane.
Right-hand turn lane.
And also, you said something earlier that we're not going to get a second bridge or a tunnel. We could ask for that at this point.
Well, I'm going to ask for everything, and we'll get what we can get.
All right.
But hold on, I'm not finished.
Right-hand turn lane?
Yeah. So I just want to mention a couple items. So we know that they're going, and if you look at the development plan, you can see that they're going to construct the Pike Field garage. Because someone asked, where are the cars going to go? Where are we going to put all these cars that normally park on that south lot? So as part of the development plan, I'll call it stage 2, Villanova will construct the Pike Field garage. Well, as part of that garage, we knew that Villanova has been saying all along that we will route cars as part of the circulation pattern of vehicles from that garage. They will be routed back behind the new dorms. So the same place where the new dorms will go, we need to have a travel lane to allow these vehicles to traverse, either leaving the garage after an event, going out behind the new dorms, and then making a right turn onto Church Walk Drive, and then back onto Lancaster. So my point is that during construction, for about 2 years, Villanova will have a fully functioning 1,200-car garage at the corner of Ethan Avenue. There will only be one egress, Lancaster Avenue. That's not going to work. So we need a turn lane on Ethan Avenue just to facilitate the traffic during construction. They've already said, they will not allow vehicles through that construction site behind the new dorms. So where is all the stacking going to happen? It's very obvious to me that there needs to be a turn lane here. The staff traffic at the last meeting, Officer Ray Mattis emphatically stated that we need a right turn lane. We need a way to control the right turn cars during events. We need that turn lane. We need the turn lane so we can shut that turn lane down during events when the garage is full. Otherwise, we're sending another 1,000 cars down through the neighborhood.
Any public comment?
Well, about this also, are you saying that the expansion of the parking lot in the area behind the houses is not going to be used at the same time?
Well, I don't know about that, but Pike Field Garage, the 1,100, 1,200 car garage.
That's not the new garage with the.
That will be the new garage.
The new garage,
yeah.
okay.
The new garage will be constructed first, and for a period of about 2 years, while everything else is being constructed, there'll be no way for the vehicles in that garage to leave that garage and get back to Lancaster.
My understanding was we're going to build the new parking lot behind the houses that are further west.
That will occur
and
as well.
that's where the parking is going to be relocated.
May I ask a
No,
question?
there's not
related to
enough
this?
spaces. You need, I forget the total number, but I believe you need at least 1,400 spaces, and they're only adding a few hundred spaces behind the houses.
Steve Norsini, I read that item 10 would require that there would be some kind of staging plan, and the staging plan would address issues like this. Do I understand that correctly?
You're correct, Commissioner.
Any public comment?
Oh, hold on, back up. So Steve, staging plan, will that address event parking in the new garage and the access to the new garage?
We will go through that, and they still will have Ethan Avenue to access and egress. It's not just Lancaster Avenue, so the garage will be open.
Yeah, my point is, a right turn lane to get access to the garage onto Ethan would make a lot of sense, especially for the 2-year period of construction. We already know from the staff traffic that it would help through life.
Yes,
But during those 2 years, all the stacking we were counting on behind the dorms won't exist. The 200-some cars are going to stack behind those. It won't exist. So they'll be on Lancaster Avenue for 2 years. You think it's bad now? I assure you. I'm leaving the board the end of this year. Good luck to the rest of you, because for the next 2 years or 3 years, this room's going to be filled with angry people.
All right, public comment?
Yeah, also on this.
Public comment. We're on public comment, Rich.
Well, we're still.
You can come back. You can go back. Let's get to public, Rich. Public comment. Public comment.
Christina Peroni. Reading from the minutes of the meeting from December 11th, 1989. It says, Father Dobbins spoke briefly on student housing and living arrangements. He told the commissioners that he met with the neighbor organizations and addressed their concerns.
Christine, we're
he
on the right.
assured, we're talking about that same topic.
The right-hand turn lane.
Yeah, I know, from 89. Ready? He assured the township that the new dormitory will house present students, and they have no plans to increase enrollment. That's 1989. So let's just talk about what's been going on for a really long time.
Christine, we're only talking about the right-hand turn lane, nothing else.
I'm so getting to the right turn lane.
Nothing else. We'll get to the right-hand turn lane.
There
That's all
were
we're talking
three.
about.
Point of order, Commissioner Spengler. She's trying to get to a
I'm
point,
trying to tell her what
a
the
very
rules are.
logically
I'm telling her what the rules
well-developed
are.
point.
I
The
get the
right-hand
rules.
turn lane.
I know.
We're not talking
I'm
about
addressing
enrollment.
the issue that he raised about will they cap enrollment.
I asked for public comment, and there was none at that time.
So next is the issue that there were three important organizations. The police said we need the turn lane. Our organization that does traffic said we need the turn lane, and our commissioner and our township manager said we need the turn lane. But Mr. Higgins, I remember at one of the meetings, said, nah, I feel satisfied we don't need it because Nick said we don't need it. I mean, it's kind of a joke that you guys are ignoring all the millions of dollars that we've spent on professionals. And I think that's really, really a disservice. And I hope anyone who votes for this does not get reelected, and I would
Thank you.
heavily endorse anybody who's voting against these.
Bill, please, let the public speak. It doesn't reflect
Any
well
other
on the
public
board
comment? Any
to
other
be
public
rude
comment
to
on
the
this
to the
issue?
public.
Hello, Phil R., Garrett Hill. I'm with John on this. We need to have the right turn lane. I didn't even think of the fact that during the course of construction, this thing is going to be sitting there with one engine, and we're going to have a lot of troubles going that way. But beyond that, even when it's fully functional, we've heard stories from residents that it's going to take 20 to 40 minutes to go from the Blue Route to Lowry's Lane or back and forth either way, one way or the other. And one of the reasons not to put a right turn lane in is because that kind of controls the speed of things, makes it a little bit safer in that corner of the neighborhood. And that's not called traffic calming. That's called poor planning. And there's no reason that we should have that. We need to dig a little bit deeper. New information has come to light with some of the stuff that they now adjusted with, and rightly so. I'm glad that they did. They made the corner changes from 25 to the radius to be 30. In so doing, the corner changes increased the crossing distance from 64 feet presently now, or what they plan to do, to 74.5 feet, adding about 3.5 seconds or 3 seconds to the crossing time. Curiously, that's the difference of about 10.5 feet. Isn't that the width of a turning lane? And if so, we can do the same, would have the same impact. Why should that 75 feet be a problem if it was the right turn lane, but it's not a problem if you're changing it to have a corner radius? It's the same thing. So that argument's gone. Secondly, the traffic study impact. Recommendation of Amy Kaminsky on May 4th in her letter, that's part of this package, Section 8, traffic impact study. The applicant's required to provide a turn lane length analysis, including the eastbound right turn lane, at Ithan and Lancaster in accordance with the methodology included in PennDOT publication 46 Traffic Engineering Manual. When will this occur? Because with 1,200 parking spaces in the Pike Garage, 300 of which will be actively used even fully functional 2 years from now or 3 years from then, and normal access only available through Ithan Avenue, that's still likely more than the threshold volume required to have a right turn lane. So it's quite possible that this analysis will show that you need it. When are we going to do it? When is that required? It's not stated. We should decide that tonight. And we should also accept and act on your traffic engineers and staff traffic recommendations that a right turn lane is warranted and needed to improve this intersection. Thank you.
All right, Rich, you have the last comment?
I agree that we should have the right turn lane. It was, as well documented, it was suggested and required by our own staff, and certainly seems reasonable under the circumstances and in no way burdens the applicant. In addition, I'm also concerned with Commissioner Fisher's issues related to parking during construction, and as Commissioner Curley also pointed out, this provision number 10. And two meetings ago or 3 meetings ago, when we talked about this, I specifically asked about the off-site erosion, the street sweeping, and there was a truck cleaning area. So what this says is the applicant shall execute a development and financial security agreements, and prior to any construction shall provide a detailed staging plan. Now, it doesn't seem as if there will be any opportunity for the Board of Commissioners to comment or review this staging plan, and also street sweeping and the truck wash areas. So that should be something that, and it really comes down to John Fisher and my wards here. This is right in the border. This is something that, along with the traffic, along with the issue of access and egress from the Pike parking lot, this provision is particularly important. So I would like to have this also be something that comes before the board and needs to be approved, not just submitted a detailed plan. There's nothing there. Anybody can submit a plan and say, that's what I asked for.
All those in favor of the...
Hold on, I got to...
We're voting on the amendment.
Yes.
Okay.
So I remain opposed to the right-hand turn lane. I think it's counterproductive. I think the idea is complete streets. It does the opposite. It makes that intersection, in my opinion, it's going to make it less safe rather than more safe. I'm hearing people say that they're concerned about safety. My opinion is that the right lane would compromise the safety. And then, John, you did mention the experts. You were accurate in their recommendations, but we also have to remember that PennDOT was neutral to the right-hand turn lane at that location. So all things considered, my opinion is that the right turn lane is problematic, and I intend to vote against the amendment.
All those in favor of the amendment?
I would like to speak. Mr. Curley has adequately stated the reasons why I don't think a right turn lane is warranted, so I will vote against the motion.
All those in favor of the motion, say aye.
Aye.
Opposed? Opposed. Passes, is denied 4 to 2. Fails 2 to 4. All right. Any other commissioner amendments?
Yeah, I have some. Are you done, John? Yeah. So item number 10, my sense is that that should be worded similar to item 13. That should be acceptable to the township, not acceptable, meaning strike acceptable to Public Works Director and replace it with acceptable to the township for the same reason that 13 is written as acceptable to the township. So I'll make that motion.
Second?
Second.
All those, commissioner comment, public comment, all those in favor say aye. Aye.
And then number 12, I don't know if there's something different about the fire marshal. I'll put that out as a question, but my thought would be that should be the same. That should be access to buildings as recommended by the township as opposed to the township fire marshal. I don't know if the fire marshal has some kind of unique authority or distinct authority from the township. So I'll put that as a question first. Steve, Bob.
Commissioner, the fire marshal falls under community development, and his review will be in accordance with all the applicable.
So my opinion is that should say the township then, and that would give, to me, that should say the township. And under your review, and then we have elected people being accountable for bad decisions if that happens rather than individuals.
I don't see any issues with that.
Okay, so I'm going to make the motion that we modify paragraph 12 to indicate that it as recommended by the township.
Second? Is there a second?
Second.
Jim Higgins, second. Commissioner comment, public comment, all those in favor?
Aye.
Wait a minute, I'm sorry. Could you give us a moment to get out of our seats?
Well, we're talking about the,
1 second?
we're talking about the fire marshal or the township is all we're talking about.
Well,
All right, anybody want to talk about the fire marshal?
Looks like
or the
Susan
township,
Stern wanted
you
to
can come up and talk about it. If you want to talk about,
a chance to do the last thing either, so when you can look up.
I did look up.
So the vote isn't final until it's summarized, and the vote hasn't been summarized.
We're
So
just
if there's
doing
anyone that
amendments.
wants to speak, they can come and speak on this
But
now.
anybody want to speak on the amendment of changing the word, taking the word fire marshal out, you're welcome to come up. All right, seeing none. Any other amendments?
Yeah, so we also need to make a decision on the 2 waiver requests. So I recommend the approval of Saldo 255-29A2 to permit the 22-foot entry-exit drive as shown on the plans.
Well, that's already in the motion.
Well, it's...
No, we
it's
have to
not-
approve it.
It's not in the motion as it has to, we have to make that decision tonight.
I'll second that.
Well, I'm sorry, I made the motion with the approval of those 2. It's in it's in there. We approve those 2 as part of the motion I just made. We
I
approve those.
specifically, I could be wrong, but I listened, and I don't believe I heard it, so my opinion is that it would be prudent to treat them individually.
It's also prudent just to pull it out anyway.
Yeah, I put those in there because at the last meeting, there was some discussion about having these Saldo waivers called out separately.
And
So
I specifically listened to see if you addressed it. I didn't
Well,
hear
it's
you
part,
address it.
I moved the resolution, but only, it's part of the resolution.
But they still need to be voted on
Fine, go ahead.
separately.
What do you got? What's your motion,
All
John?
right, so I motion the approval of the waiver to allow the 22-foot entry-exit drive.
Is there a second?
Second.
Commissioner comment?
I have a question. Maybe engineering can help with this, Roger. Is this all entry-exit drives? including the ones off of Ithan Avenue? And I apologize because I didn't.
My
It just says
recollection,
shown
this
on
is
the plan. It doesn't say what
these
page.
are only the exit entry drives that are outside of the work area. That this is my recollection from our last meeting, that some of us had determined that those were existing, and the advice that some of us interpreted from our solicitor was that if it's an existing condition, it is not subject to the.
No.
But these are
These are
not-
drives that should be 25 feet under new construction, but where there is not parking, they ask for a waiver so that they could keep less impervious and more trees.
Okay, Roger wants to give us the.
This is comment number 3 under Roman numeral 2 of my letter, which starts on page 3 of 11, continues to page 4 of 11, and it's the drive aisle that's behind the housing that goes from the church walk area down to the parking off of Ithan. The entrance at Ithan is 25. It's the drive aisle that's behind there that's 22.
Now, Roger, with the, with the ultimate plan of running vehicles down that drive aisle during events, just as a way of egress, potentially having vehicles going in both directions, is 22 feet adequate to have?
I believe it
vehicles?
is, yes.
And also there are vehicles parked along that aisle.
Outside of the 22 feet.
And does that allow for pedestrians to walk?
I believe there'll be sidewalks along there too, behind the buildings.
Okay, I mean, my concern here on this is you have during large events, or any events for that matter, not even events, just you have cars traveling in both directions, and then you have students, 1,100 students living in that area. It just seems, we just went through this in my neighborhood when the street wasn't more than 23 feet. And we had to go to parking on one side of the street because we didn't have enough room for the pedestrians walking.
Well, you're not allowed to park here, John.
There is no park, there's no sidewalk. There's no sidewalk there.
It's head-in parking in different places. But the point is, there will be students walking, there will be people walking, there will be cars going in both directions. And I just think, while it would be nice to not have 25 feet to preserve area for trees and grass, there's a logistics issue here. It's just, to me, it's nonsense. It's, here we go again. You're trying to fit a very large peg round into a very small square hole. And it doesn't make sense. I'm sorry. It's another political decision.
Was your motion seconded, Don? I don't remember. Was there a second? John seconded? Okay, all right.
All right, so, okay, it was seconded. So, first of all, there are no sidewalks in this area where the 22-foot drive aisles are. There are sidewalks behind the existing housing that I guess pedestrians would be able to access when they're parking in these parking lots, but there are no sidewalks. Is that correct, Roger? I have the drawings here. If you want to take a look.
Yes, the sidewalks are behind the proposed housing.
Okay, so is that what you meant? That's where the sidewalks are, or?
Yes. Adjacent to the parking areas that are back there.
So they would be in front of the head-in parking. Okay, but what about pedestrians that are trying to get back to the garage? Would they be likely to walk in that aisle? I mean, are they going to find the sidewalk? Or are they going to walk from? And it seems like a lot of people, thousands of people, trying to get back to their vehicles. And we have these narrow lanes, these cars trying to pass each other, and then pedestrians in the mix. I just foresee issues.
Any public comment on the 22-foot? All those in favor of approving that waiver say aye. Aye. Those opposed?
Nay.
Nay. It passes 4-2.
And then I move the approval of a waiver for 25527 to permit the reduced 30-foot curb radius at the
I have a
southwest
second?
corner of Ithan,
Second.
Lancaster Avenue intersection.
Commissioner comment?
Just reiterate, PennDOT did have a position on this. It wasn't ambiguous. They said if you weren't doing a turn lane, you should do the 35-foot radius.
And the reason being is because of the trucks and others making that turn. With a 30-foot radius, I'm not sure where the stop bar on the opposing traffic is going to be.
And
That's addressed in the letter that's in our packet, and in fact, our engineers are recommending the acceptance of the 30-foot.
Can we see a drawing of it? Can we see the drawing of it? Let's see what that looks like.
Rich, if I can just also add the comment, again, Officer Ray Mattis clearly stated that during events, it's very common for trucks and larger vehicles, buses, lots of buses delivering attendees to the lots, routinely going over the sidewalk, routinely. So, you've got 100 people standing on the corner waiting to cross, and here comes the bus making a right turn, and they're actually driving right over the sidewalk. So the police officers are constantly pushing back everyone, saying, move back. But, the police officers aren't always there. Okay, they're not always there to do that. So, the whole reason these metrics are in place is because they work.
Can we see the drawing?
So, John, I do, though, believe that there are a lot of technical people who would say
can you
that
put it up on screen?
the radius as you defined it would be less safe than the radius as we are approving it.
Okay,
So
well,
if part of
who are they?
Allow me to finish.
Yeah, but who are they?
If part of your, John Nagel said it would apparently, you have to find the section. But generally, a tighter radius is a more open intersection is going to create more speed, and that speed is going to be dangerous for the people who queue at that intersection. So one of the lessons that we should all have, or should all realize now, is that there are conflicting opinions from experts, and everything is a trade-off. So we are trying to pick the one that is, in our opinion, the best trade-off. My opinion, the best trade-off is the 30-foot radius.
Jen, could we turn on the overhead? Ms. DeStefano? Thank you. There we go.
We can zoom into the upper right corner. Alex Tweedy with Nave Newell, the civil engineer for the applicant. I think what's lost in this waiver request and is important to note is there are two parts to the waiver request. We heard a couple concerns at the last meeting that were addressed. Obviously, turning movement. Township staff, and I think Steve Norsini specifically, had concerns about trying to keep this stop bar setback at the 30-foot maximum recommended in Amy's letter, and then also improving this while trying to balance, as we've always talked about, the minimum length of crosswalk possible. What's important to note is we're asking for a waiver for a 30-foot radius, but what we worked out with Amy and Steve was bringing in a 10-degree angle shift to open up the throat of this. So in blue, you can see this is what code requires, a 35-foot radius. Though we're asking for a waiver for a 30, we're actually giving you a bigger intersection and a better turning movement. This alignment allows for the trucks to adequately make a turn, gets you the 30-foot stop bar offset that the township staff wanted, and still maintains the crosswalk length at only a 3-second increase from existing, which is what was reviewed by Amy, and I believe she issued an email to everyone confirming her review of it and finding it acceptable.
So what is the distance between the right, this is, let's see, right lane, Ithan, northbound stop bar. So you're referencing from, the 30-foot is referenced from the right-hand lane. Well, what's the distance of that right-hand lane stop bar from the corner? It seems like it's awfully far back from that corner.
Correct, because it has to be behind the pedestrian crosswalk.
I understand that. So, it seems to me that we're not at 50 feet any longer from the stop bar, but we're sure as hell 50 feet from the corner. So, it's drivers don't perceive these things. They just drive to the corner and stop. So I don't think that, all due respect to staff, but that stop bar on the right-hand side seems awfully far away from that corner. And I understand it has to be behind the pedestrian crosswalk, but that pedestrian crosswalk appears to me to be further back. I don't know if it is, but it seems awfully far back from the corner. It's not even at the same, it's not even parallel to Lancaster Avenue.
Yeah, it does not look parallel to
It's not
Lancaster
parallel.
Avenue.
It's got an angle. No, it's not. And John, my point is, we've moved the right-hand lane stop bar back probably 10 feet. So we could be only 30 feet for the other stop bar. And it's kind of like, I don't know, it's bait and switch in my opinion.
Is there any public comment on this issue?
Yeah, before, can I see the other, you have 4 other intersections there. What are the other drawings that are there?
Just the existing condition and what was previously proposed with the 25.
Can you show us the existing condition?
The angle's actually the opposite direction. It's about 5 degrees the other way.
Yeah.
And you can see the original stop bar is not as far from the corner.
I mean, this looks to me like you're getting significant improvement on what you're asking for. Am I missing something? It seems like it's moving very much, it's not completely where John Fisher wants it to be, but it's moved very much in that direction.
I mean, we believe so. We tried to work with Amy to come up with a compromise to address all the concerns raised at the last meeting.
Don, pushing the stop bars back further is not an improvement. That's compensating for allowing large trucks to make that turn and not cross into the other lanes of traffic.
What are the other 2 sections you have there?
Just well, we need to zoom out.
Jim, could you zoom out, please?
So this is the existing condition. This was the previous request with the 25-foot radius and the 50-foot setback. This is what we're currently proposing, also showing the 35-foot radius. And then this is if it were a 35-foot radius.
What is the distance? We need to have a normalized measurement here, but what is the distance from the center of the cartway on Lancaster Avenue to the stop bar? The existing stop bar?
Yeah, I don't currently have that measurement. I'd have to look it up.
Do we have the distance from the edge of the cartway to the stop bar on the existing condition?
Yeah, the only measurements I have are compared to the original approval. With the crosswalk alignment hasn't changed. We've just, from the 25-foot radius review, we've just changed. We've held the crosswalk in the same location and adjusted the stop bars in the radius per the concerns at the last meeting.
Mr. Chairman, if I may, if I can ask the question to you, the reason why the crosswalks now, are those actually being relocated or are those going back in the current position that they're in right now as they sit today? Or are you moving those back?
Well, we're rebuilding all the curbs at that intersection, both on the east and west side, so we have to reconstruct them to the latest PennDOT standards.
The crosswalks, are they in the same position as they sit today? Or are you?
Well, they can't be because the road's not in the same place.
Okay, but you're going to move those?
Yeah, we have to.
Is that for pedestrian safety of why you've pushed those back a little bit from where they are?
Well, the road's widening 6 feet. We're improving the radius even on the eastern side of that intersection. And we have to upgrade those ramps to the latest PennDOT standards and construct them, appropriately in those areas. So that's, all those weighed together came up with the latest alignment.
And John, I think to this point, by driving by there quite a bit, for some reason, Villanova students like to stand right on the curb. So I think by this repositioning of this will actually set them back from the road. So I think this improvement at 35 is good. The only thing is with that turn where the 35 is at, of whether or not there could be some type of bollards that are installed there because trucks are going to cut that curb the way it is, or is the curb being built up enough so that someone cannot go over that curb, or is it going to be built up high enough that you don't have trucks that are going to be going over the top of the curb? I mean, that's because you got quite a few kids that'll be standing there, or pedestrians, if there's a way to elevate the curb, because I think where these are positioned, these are going to help a lot of the pedestrians that want to stand right on the edge of the curb to be pushed back.
I mean, I agree with your position. One of the concerns is if the ramps are too close together, you can't PennDOT requires 8-inch curb, but a lot of times when you put the 2 ramps right next to each other, PennDOT lets you only do a 2 or 3 inch curb in between those ramps when they're butted up right against each other. The greater separation you get in between the individual ramps, you can actually get up all the way to that 8-inch curb, protect that immediate corner, and then at the next ramp, drop from that 8-inch back down. So this alignment allows better protection, like you were saying, immediately at that curved point.
Any public comment
I would like to remind the board
on
that
this issue?
I would like to remind the board that the curb ramps will be reviewed again through the HOP process and the signal plan modification process.
All right, anyone want to discuss the 30-foot curb radius?
Jane Galley, Barclayton Road. The only question I have is, what size trucks were these based on to make this arrangement? Will a fire truck fit down coming from, if there's a big 2 or 3 alarm thing, besides Bryn Mawr Fire Company, will Radnor's trucks be able to make this radius without plowing over people, or, again, for safety purposes? I still think you're going to have trucks running into people that are going north on Ithan that are waiting to turn. It doesn't seem enough.
All right, all those.
Well, hold on. This resolution, all right, what you've asked is to permit a reduced 30-foot curb radius. But in fact, it is a 30-foot curb radius with a 10-degree angle, or is that or is that not the case? It looks like that's what you want to approve. And you know, I'm not going to approve this, and I think that the audience knows who the 4 are. So, but let's make it clear what you are asking for here.
That seems reasonable. So my sense is language to ensure that the intersection is constructed the way that you worked it out with
Commissioner Booker, there's no waiver needed on the 10-degree angle. The waiver is specific to the radius. So that's not an issue that would require a waiver. It's a design issue, but the waiver is specifically to the radius length.
Understood.
So
However,
they have
you may as well make it clear what we're going to build here.
So Steve, you're saying they have to put in the 10-degree.
What I'm saying is you as a board have to vote on the radius. You do not have to vote on the 10-degree. It's part of the design of what he's putting forth. That's not a waiver request.
So the design will be on the plan, they'll have to do it.
Correct.
Thank you, that's it. All those in favor, say aye. Aye. Opposed?
Nay.
It passes 4-2.
And then, John Rice, do we need more language on the 2 items from the RTU letter, or is it sufficient what Bill provided?
No, I mean, I'm going to redraft that paragraph that incorporates RTU to eliminate those 2 items as conditions. I mean, I don't think there's any additional,
Okay.
I don't think the board needs to wordsmith that. That'll be drafted, it'll come back around, it'll be sent to all board members before it gets signed.
All right, before we vote, there's a woman back there.
Wait, another amendment?
Wait a minute. Well, let's let this woman speak. She's been waiting for a long time.
Yeah, Ms. Susan Stern.
I didn't recognize you, I'm sorry. In your attire, I didn't recognize you.
Susan Stern,
Bill
Wayne,
Clinton.
Pennsylvania. I've read some of the stuff that's gone on in the paper the last week or two. And what's clear to me is that some of the upset that has occurred that we can't really change is that at points in the past, language was not as clear as it could have been with regard to what agreements were put forth, how they were going to be upheld, and have the integrity really kept. Which brings me to condition number 8 in tonight's resolution. The applicant shall construct all public improvements shown on the plan. I suppose that we could sit here tonight in this room and feel comfortable that what that means is that they're going to build the bridge. Except there's not a bridge at Lancaster and Ithan, and there's not a tunnel at Lancaster and Ithan. And so this is your opportunity, the 4 of you who are going to vote for this, to be clear. Villanova must build the church bridge. And you could even perhaps think, well, of course they're going to build the bridge because it's in the conditions of approval for the CICD, except that it's not. What the CICD actually says with regard to the bridge is number 6, appropriate fencing will be provided on both the north and south sides of Lancaster Avenue in the area of the Church Walk pedestrian bridge. Now, that doesn't actually say that Villanova has to build a bridge. What that actually says is if they build a bridge, they are required to put in fencing on the north and south side. And it's a very different condition to say that when you build the bridge, or if you build the bridge, you have to put on the appropriate fencing, and to condition them to build the bridge.
Susan, they have to build the bridge. If they don't, we'll have the money to build the bridge.
Mr. Spengler, with all due respect, they were supposed to build a tunnel, and we were supposed to have the...
We got no funds.
Let's-
We got
let's
the funds.
handle
we
it.
could
I'll
build
wait
it.
for you to finish
Let's
interrupting me,
let's
and
try
then
to
I'll
handle
continue.
it this way.
So all I'm asking is that at this point in time, this is your opportunity to say in the conditions, you must build the bridge.
All right.
That's my only comment.
Let's handle it this way. Paragraph 8, this is for the applicant now. Paragraph 8 says the applicant shall construct all public improvements shown on the plan. Mr. Cornelia, is there any question in your client's mind that public improvements in this context includes the bridge at Church Walk?
No question at all. And I believe the conditional use approval states that they shall build in accordance with the plans submitted during the conditional use process. I believe I saw that somewhere in the conditional use approval as well. But yes, public improvements.
So if there's any
includes pedestrian
ambiguity in this paragraph 8,
currently-
you cleared it up, you're going to build, your client is going to build the bridge.
We're building the bridge.
Thank you.
Can I just add?
I'd like to make an amendment to that. That's not good enough for me, I'm sorry.
Okay, excuse me, John.
And John, all due respect, we need to put it in here.
No,
We
I
need to put it in here.
I
Have we
agree,
not
but-
learned?
Yeah,
Okay?
I'm not arguing about that.
Yeah.
I'm just pointing out that paragraph 8 refers to the plan. And plan is defined in the second whereas clause as including all of the sets of plans, including the bridge plan. So you have all the sets of land development submissions. They're all collectively defined as the plan. One of those plans is the church walk and bridge. So, but if you want to add additional.
Yeah, I want it to be
can I just-
binding in a very verbose. Look, guys, this is exactly what happened in 1990, where we weren't
Not
specific
exactly.
enough.
Yeah,
No,
see,
you're right.
I think it's a little, to me, what happened in 1990 is the bridge wasn't on the plan, correct? The bridge was not on the plan in any
No,
of those.
there were no-
and
at the time of the approvals,
In 2015, the bridge is on the plan. So
Here's my amendment, just to clarify. It's harmless, in my opinion. The applicant shall construct all public improvements shown on the plan, including the construction of the pedestrian bridge across Lancaster Avenue at Church Walk.
Second.
And that there's just no reason why anybody would object to that, correct? There's just, John Rice, there's no objection to that. That's, okay, consider it done.
Public comment? All those in favor? Wait a minute, did you make a motion? Who seconded?
Rich did.
Rich did. All right, all those in favor say aye.
Aye.
Opposed? It passes
4 to 0.
5 to 2, 5
Fi-
to
5 to
0
2.
with one abstention.
5 to 0.
Okay.
All right, wait. Are you, is there any further amendments?
No, Rich, I'm going to let the public give one last talk before we let the commissioners give their final say, and then we're going to vote. Does the public have any final comments?
Hold on, point of order. If he has amendments,
Yeah, I have an amendment.
he needs to make his amendments.
I move we amend this to include a requirement for Villanova to build a pedestrian tunnel as provided in the plans on the table here and in accordance with the original designs from 1993 and before.
Is there a second to that?
Second.
Commissioner comment, public comment? All those in favor of the amendment say aye.
Aye.
Opposed? Opposed? Fails 3 to 2 with one.
Yes.
Yep, works. 3 to 2. It's good enough. All right, public comment?
Philip R. Garrett Hill, just one quick comment. Appreciated you put it in language about building the bridge, make it official. Villanova's timeline for construction of this bridge happens to be, according to their records, before the West Lancaster Avenue parking, which is going to be somewhere around April of 2016. And that's probably the latest time to really start construction of that bridge to have an impact. But would you please consider making this part of your conditions, that this be built and usable, not best efforts, but built and usable before housing is begun construction in 2017? Reason being for three things. One, that builds trust with the community that you've got a timeline here. But secondly, it also means that you have time for forging new pedestrian behaviors. If you do it much after that, you don't have people using this yet, and I think you need to get that kind of behavior modification. But go ahead.
So it's my understanding that that's built into the, is that correct? Villanova, can comment on that? Is that that's in the phasing of this, it is, so that the bridge would be built before the residence halls are built?
I don't know if the...
You can't speak from the audience. Excuse me. You got to go up here. People want to listen to you.
Nick, would you like to put some dates around this one?
And, well, I'll let that go. As I believe there's a phasing plan, and Alex is more familiar with it than what I am, but the bridge will be commenced and constructed prior to the finalization of the dormitories. They may be constructed simultaneously, but the bridge will be finished before the dormitories are occupied. So according to the phasing plan.
Thank you.
I just have a follow-up.
Yep.
My reading of the plan said that this was going to be started before the West Lancaster parking lot was being started. That's well before the housing is. And it was according to their schedule to be completed by the time the housing was started. So what I'm asking is that be officialized and put in there an idea of building trust with everybody about the whole thing, to get compliance that this thing is actually done, and lastly, to build those modifications of actual pedestrian movement before we go ahead and have this the other buildings made.
I would like to...
Excuse me. Let's get the public comment, and you get to your...
I'm going to amend my last amendment.
Any other public comment? All right, John.
I just want to add, I added the phrase, including the construction of the pedestrian bridge across Lancaster Avenue at Church Walk. I'd like to add, to be completed prior to the completion of the housing.
You mean the occupancy of the housing?
No, I think we're looking for before the construction is completed on the housing.
Or before the construction of the housing commences.
Wow. Is that the schedule? It was in the schedule that way, and that's why I'm a little disturbed that Nick has just put forth a whole new plan. So this is why, if it's not in a resolution, it doesn't mean anything. So we really need to have dates. I would say my original motion, amended motion will be to add the phrase...
If you don't mind, make another motion. Don't amend what
Okay.
we already... Make a motion that's
Okay.
distinct from what you did in the
Okay,
past.
numbered item 8 on the resolution, the applicant shall construct all public improvements shown on the plan, including the construction of a pedestrian bridge across Lancaster Avenue at Church Walk, to be completed prior to the completion of the housing dorms.
That's vague, John. I mean, it's just like, before the occupancy is the same thing. It's not completed.
No, occupancy is much later, so you can...
But I'm still not clear on whether you want that to be built simultaneously or concurrently with the construction of the dorms, or prior to the dorms being constructed.
What I don't want is the dorms to be constructed and finished before the bridge.
Then say occupancy, John.
Well, that didn't work last time, Bill.
All right. So
My sense is to get what you want, the best thing would be use Bill's language of occupancy.
Now, hold on.
Make your
Now,
motion.
we're missing the subtlety here. The surface lots will be constructed behind all of the existing structures westbound of this site. We need a way for those people parking there to get across Lancaster Avenue. And that's before construction is done. So I would argue that it should be done according to the original plan. And I believe it was, the bridge will be constructed prior to the construction, the beginning of construction of the dorms.
Are you going to make a motion?
Second.
That is my motion. So
Any other commissioner comment? Public comment? All those in favor, say aye.
Aye.
Opposed? Opposed?
Why don't you try the other way?
I think Jim Higgins or Bill should do this because you guys did this back in 1990. You did this, right? We
Can
went through this.
I make a suggestion?
I wasn't here in 1990, John. I started in 92, for your information.
No occupancy of the dorms until the bridge is
Well,
completed.
that's right, but, it was too easy doing it that way, so let's not do
But
anything.
John, here's the thing.
They can't occupy it, and you have to enforce it.
But what stops the manager at that time? It won't be Bob for certain. He will never let that happen. But some manager could say in 4 years from now, if Bob decides to leave, Bob, if you decide to leave, Bob, you would never let this happen. I know that. The point is, this is exactly what happened 15 or 20 years ago.
But
it wasn't policed. There was no one there.
Any condition you attach, even the one that just was voted down, has to be policed. It has to be policed.
But
somehow.
it wasn't, and it may not be.
Well,
Jim, you were here to vote on 90-495.
John, wouldn't it make more sense that the completion of this bridge be tied to the completion of the West Lancaster parking?
That's what I'm stating.
That's what we really need.
Right. That's what I'm trying to state. So
Because that's when you're going to get the big influx of people coming across the street.
So the resolution should read. Bob, would you like to say something?
Yes, please.
Bob Morrow, Villanova University. We're working with PennDOT to build the bridge, but having it finished before all the parking is not likely because of all the highway occupancy permits and all that's required in that. So the phasing schedule shows us building the parking first, all the parking, before we start the dorm construction. So there were other public comments earlier concerned about would we start tearing up the main lot before the parking is complete, but no, we wouldn't do that because we need that. But we will have the bridge done before the buildings are occupied, but we'd ask you not to put the condition it has to be a bridge completed before the dorms construction starts because we need that time for all the PennDOT approvals. And PennDOT has already said they will assume project management responsibilities for the bridge.
Okay, so we'll amend the motion to state.
Not amended motion, starting a new motion.
Okay. Number 8 will read, the applicant shall construct all public improvements shown on the plan, including the construction of a pedestrian bridge across Lancaster Avenue at Church Walk prior to occupation of the new dorms.
Second.
Okay, it all sounded fine. John Rice, any concerns on your end? No. And then Villanova, is that something
Fine.
that there's a concern on your end? So that's the spirit of ensuring that the bridge gets done before the impact of the bridge is realized in full.
Other commissioner comment? Public comment? All those in favor, say aye.
Aye.
Opposed? All right, any commissioner comment on the final motion? Well, public comment? We're ready to vote? Commissioner comment?
Well, yeah, no, it says commissioner comment. So this is the preliminary approval, but in fact, there's no way to stop this going forward after this vote. I think that it's been a very long process here, and we see that Villanova has been granted a huge benefit to the university. I think that it will be detrimental to the quality of life in many respects due to traffic, noise, density. I think this is too big for our neighborhood, but I don't see any way or anything else I can do about it at this point. So I've done everything that I can to make this as least impactful, and I hope that the folks recognize that.
Any other commissioner comment?
Well, I share some of the same comments as Commissioner Booker. We've worked hard on this to try to lessen the impact to the community. It's clear to me the community is not fully satisfied. They may never be satisfied, but there are many things that didn't happen that needed to happen. But the most important one was getting 2 pedestrian bridges, because that was my ask 3 years ago. My ask 3 years ago was to have 2 bridges. What I believe will happen is we will see a large number of crossings at Ithan. We potentially may see accidents and injury at that intersection, and only then will this township and the university realize they needed to do something. It's very sad to me. I said this earlier tonight, that I take my commitments to the public very seriously. I've served on this board for 7.5 years. When I took the oath of office, I meant it. And I uphold the laws of this township, and those laws include those ordinances from 1990 and 1995. I'm disappointed, very disappointed in this board for not recognizing the gravity of those in this activity tonight. We had an opportunity here to get a second bridge. We asked for it early. It's no surprise. We have evidence now that they agreed to it 20 years ago, all the way up until 1995, or actually 1998. There was action, activity, good faith effort to build a tunnel, yet it didn't happen. So I'm very disappointed in the university, not those sitting here tonight, because most of those sitting here tonight are new to the university. But the university made a pledge and an obligation to this township, to the residents of this township, back in 1990, 1993, 1995, in public statements all the way up and through 1997 or 8, that they were going to do something to alleviate traffic, congestion, health and safety at that intersection. And here we are, 15 years later, and it's not going to happen. That is very disappointing to me, very disappointing. I look forward to leaving this board at the end of the year knowing that I worked hard on this issue, but I'm very disappointed in the outcome. I really think we needed that second bridge. I appreciate what Villanova's done through this process. They've been patient, but I'm disappointed that we didn't get everything we needed. So I'll be voting no against this resolution tonight.
Any other commissioner comment?
Sure.
Well, I just wanted to say, when I look back as to the plan that was first presented to us, this final plan is dramatically different, and we have greatly improved the project from the public standpoint. The issue about the tunnel and the other bridge, it's unfortunate. We need to keep digging, see if we can find some facts, because it's apparent that something was not done appropriately, although this board, at least in the 6 years I've been here, has worked very hard to make sure everything was above board and transparent. That may not have been the way things operated in the past. I always keep in mind, try to keep in mind the codes and look at all the changes we've asked for and the suggestions from the public in terms of what do the codes say. We talk about our experts. Sometimes we get conflicting opinions from our experts, so we have to make our own judgments. And I think this project is going to be very good for the community. I hope Villanova sees the wisdom as they move forward to bridge over to from the pedestrian bridge over to the dorm to increase the usability. And then that way, if they had an elevator in that corner, that would address another public concern, which was an elevator for handicap access to the bridge. But that's not part of this resolution. It's just a desire that I'd like to see accomplished. And I plan to vote for this.
Yeah, so I believe in the project. I think it's a good project. I believe it will benefit the township, the university, and the neighbors immediately around the university. I also think everyone worked hard at mitigating the impact. So that's Villanova, the township staff, the Board of Commissioners, regardless of the side you were on. Lots of people participated in an attempt to mitigate the impact of this. On balance, we had a long, comprehensive project process, and this is the one that survived. This is the plan that survived. I believe it. I believe, all things considered, it's the best plan that we could put out there. And I'll just say that the biggest outstanding item out there is certainly there's a lack of faith in the community that there was a commitment to a bridge. And regardless of how that happened, there certainly certainly that appearance was created. Certainly the community believed there was a commitment to a bridge. And my opinion is that that is addressed in this resolution, that the commitment to the bridge is real and it will be implemented in a manner, and it can be verified and checked in a manner that it was not done in the 1990s. So obviously I intend to support it at this point when the time comes. Thank you.
I am going to vote for the resolution as amended. I'm pleased to do so. What we have here is, it's a classic case of private development rights versus the police power of our government to regulate the health, safety, and welfare of the community. And we cannot deny any developer his or her or its rights to develop without due process of law. In this case, I think with the 40 months of review, that's where we are tonight. Somebody said that they're blaming Villanova for this very thick file. Well, the 40 months of review was to accommodate all the voices in the community. But with those 40 months, I think we've accomplished a lot. We've come from a position where Villanova had to move to the center. I think the rule of law that I support, some people may say I'm pro-Villanova. I'm not pro-Villanova. I'm not anti-Villanova. I'm pro-rule of law. I rely on this, our zoning code, our subdivision and land development ordinance, our home rule charter, the municipality's planning code, the right to know law, the government in the sunshine law, that's not the exact name of it, and I rely on our inferior boards to enforce and to administer all those laws. So in my review of this whole project has been to make sure that those inferior boards and commissions did their job under the laws that I just mentioned, and I think they have. My vote can't, the people that are voting for this, we're not going to please the Friends to Preserve Radnor. I know you've been out here for 40 months, you're opposed to it, but we're trying to represent the entire community, not just your interests. And quite frankly, I think this is a good project. I think to take this big sea of asphalt and to convert it into dormitories and a performing arts center and shops and a parking garage is good for the community. And since there have been a lot of negative things said about Villanova, I'm going to say a few positive things about them. This is their study, it came out of their annual report, and you can say it's biased because they hired the consultant. But here are the numbers that they claim they contribute to Radnor Township. The annual direct expenditures and indirect expenditures benefiting Radnor Township are $50.99 million. Now cut that in half if you don't believe the number, or cut it by 75%. It's still a big number. For Delaware County, it's $186.56 million. For the 5 counties around here, Philadelphia, Bucks, Montgomery, Chester, and Delaware, it's $666 million. There are 13,000 people on that campus that either work there or attend school there, and they all contribute to the well-being of Radnor. If we did not have Villanova in this community, and again, I sound like I'm a shill for Villanova, but I'm not. I'm just trying to counteract some of the negative things that have been said for all these months. Many communities in Pennsylvania would die to have an institution like Villanova present here. So that's why I'm voting for it. Now let's get back into this business of the bridge, tunnel. If you think we should have 2 bridges or a tunnel and a bridge, then forget everything I'm going to say. The fact of the matter is that the bridge over Church Walk will be safer than a bridge at Ithan Avenue. And don't take my word for it. Take the word of Gilmore and Associates. Mr. Drummond is here tonight. Amy Kaminsky, his colleague, did the study. I think it's Frank Tavoni Associates of Tavari, thank you, of Villanova did the study. And what they found was that, well, the times have changed since 25 years ago, folks. Sorry. There's a whole new campus on the south side of Lancaster Avenue, the South Dorms it's called. Those students, to get to their classes, go on the south side of Lancaster Avenue and cross now at the surface at the chapel, at the church. I've been out there. I went out there with Amy Kaminsky. The Villanova people were there. I went out there with the former Commissioner Black at the request of Commissioner Schaefer, I believe it was, and I saw it. It's a huge number of students are crossing at Church Walk every morning, and I presume it's all day long. Yes, there will be students and people crossing at Ithan Avenue. We can't do anything about that unless, as you said, Commissioner Fisher said, we should have two ways to get across the highway. I don't think we should. If this board were to vote for a second walkway or bridge or tunnel over Ithan, over Lancaster at Ithan, we'd be signing the death warrant for this project. This project would never get built, and Radnor would be a loser. The community would be a loser also. So as I said, I looked at all the studies. I had email exchanges with Ms. Kaminsky. I started out as a very serious skeptic of the wisdom of having that bridge at Church Walk, but I came around to believing that's the better of the two options. If you want to have a perfect solution, sure, build two bridges, but you're not going to have that. As I said, that's a death warrant for this project. We've heard the solicitor talk about the legal issues regarding the resolutions of 1990 and 93. I'll just add one thing. If there were three parties involved, Pennsylvania Department of Transportation, Villanova University, and the Township of Radnor, Villanova agreed to use best efforts to get the bridge designed and constructed. Their obligation or their performance was explicitly or expressly dependent upon the participation and contributions of Radnor Township and PennDOT. When that participation and that contribution was not forthcoming, then we have what is, in my judgment as a lawyer, a failure of condition. And that relieved Villanova from the obligation of building the bridge. But you know something? All of that is moot. That's irrelevant. As I said, times have changed. The real problem for the crossing of Route 30 is safety of the students and others, and that is best assured by the current design of having the bridge at Church Walk. And don't take my word for it. Take the work of our own consultant and the consultant of the university. So that's what I have to say about this resolution. I'm glad we're finally at a point where there's a preliminary approval, and I'm happy to vote for it.
I'd like to call the question. All those in favor of the motion say aye. Aye. Opposed?
Nay.
It passes 4-2. Thank you.
Commissioner Spengler has to be excused. He has a relative that he has to attend to. And at this point in the agenda, we will go ahead and move to the second item under Public Works, and that will be the discussion of the draft plan laboratory office amendment by Ritu Associates. I know Commissioner Schaefer has just been dying to say something all evening, and now she'll have her opportunity. And we have Mr. Gabriel representing Ritu in front of us, and please go ahead.
See if I can that's what we want to do. Good evening, everyone. We were here 2 weeks ago. Your last meeting, we talked a little bit about the draft amending ordinance. Individual members provided some feedback. We have since provided you with a memo with a little bit of follow-up on that feedback. that hit some of the highlight issues or aspects of the ordinance and circumstances out there in the PLO district that you wanted to see discussed, at least as individual members. Ultimately, I think what the board will want to do is agree at least on certain aspects that you would like more feedback on, either from RTU or from Township Planning Commission, County Planning Commission, or others, in order to keep moving the process forward. But I'd be glad to go over at least a little bit of the memo that we submitted to you on some of those aspects that you brought up 2 weeks ago, and our reflection on those issues, if that's how you'd like to proceed.
That would be helpful for me.
Okay. And I'm going to start the back of that memo. The last item was lot coverage. So it's the second page of the memo. Yes. And I'm going to, at some point, get this in here. But I just wanted to point out about lot coverage in the proposal. The draft ordinance talks about lot coverage being allowed at 45% within the PLO. Currently, your PLO allows up to 55% lot coverage. Turning around, that's 45% of green area required currently under your current ordinance. This proposal requires 55% of green space.
Including or excluding right-of-way? Specifically, the right-of-way under I-76 for the site that this belongs to.
For site area, it excludes I-476. It's excluded from the site area. So we're still talking about the 18.2628 acres for the biomed site in particular. What that translates into, utilizing the 18 acres at the biomed site, is nearly 2 acres of additional green space under the proposal as opposed to the current regulations. Looking at another site, say the Penn Medicine site, which is about 8 1/3 acres, the proposal results in an additional 35,000 square feet of green space being required of new development going on there. So just to give you a little bit of a sense of what the difference in the current ordinance versus the proposal and how that results on the sites was that information. The second thing was Commissioner Fisher had talked about promoting certain uses over others, and wanted to point out, and we did in the memo, that there are percentages allowable in terms of the total square footage of a development. For example, on sites greater than 10 acres, 65% of the total floor area of a development would be allowed as office space, 35% in multifamily development or hotel, 10% for retail, restaurant, and so forth. Those percentages, to a certain extent, do already encourage certain uses amongst the list of permitted uses by virtue of those numbers, some numbers being larger than others. But certainly, if the board felt that it wanted to encourage, incentivize particular uses within that list of permitted uses, identifying which ones those are, we can then start working on those, whether it's through height or some other variable or factor. We can certainly make that happen. And if there are uses within that proposed list of permitted uses that the board as a whole doesn't like particular uses, we ought to get rid of them. As opposed to discouraging them, we ought to get rid of them. So that was our at least our follow-up to that comment. Then the two things that may be most key, one has to do with transit use incentives. Commissioner Curley was particularly interested in seeing more of those within the proposal. Not just the site conditions that are typical or traditional within a zoning ordinance, but certain other incentives for transit use. There are other communities around the country that are currently incentivizing transit use, either through a fee related to the development, a proposal that would go into a designated fund, much like the capacity improvements fee that we've already got in the proposal. But then that is used for transit and to incentivize transit use. And in other communities, there are also a lot of good arrangements with the transportation authorities themselves in terms of value passes and other arrangements to promote transit use. But
So
that
the
requires
first-
the cooperation of those
The
authorities.
first half of your statement, not the one involving transit agencies, you talked about a fee that the ordinance we could establish a fee that would be imposed upon the developer, and that fee would then go into an account under our control?
Yes.
All
Yeah,
right.
it can be made part of an overall transportation management program, and you can designate that towards helping to incentivize transit use. That's what other communities around the country are doing.
So the money comes to us, but then we could use it. The developer then builds his facility, has tenants, and those tenants have employees. Are you saying that that money then, we could give that to the employees?
Through either helping to discount the cost of transit use, because that's one of the primary incentives that users of transit find attractive to help to facilitate their use.
Okay.
So that's what other communities around the country are doing. The state of Oregon even has a program where where businesses who will help to discount the cost of transit use by their employees then get what's called a state business energy tax credit. So there's a lot of different things going on. I don't want to get too complicated with what we try or discuss here, but those are some of the different ways that communities are incentivizing transit use. Yeah. And then the last thing has to do with
Well,
the
hold on, Steve.
go ahead.
How could we do a tax credit? What tax credit are you referring to?
Like I said, this was the state of Oregon, but I'm just as an example of something.
I don't know of any way in Radnor we could do a credit. If we're going to offer a credit, I would offer a credit to people who want to bring in laboratory use. That's the first thing I would do, right? So I think it would be a much better plan to incentivize the current use as planned laboratory office, and the whole. So we could subsidize. If we wanted to offer a credit, I would be much more inclined to give a credit against business privilege and mercantile tax for anybody who wanted to bring laboratory space back into Radnor Township. But I don't see how we could provide any other kind of credit. Matter of fact, I've been told that we couldn't do that under any circumstance. So I'm at a loss for how we would do that, as you're suggesting.
A tax credit, you mean?
Yeah.
You can't do that? I wasn't suggesting that Radnor Township do that. I was simply offering that the state of Oregon even goes that far with
I know, but when you
as
say that, Steve,
unusual
people
as
think
possible.
that we can do that too. We can't do that.
Well, what I heard him say was it would be a fee charged for the privilege of developing, and that fee would go into an account under our custody, our control, and then we could
Yeah, he
distribute
did say that, but
to
he
people.
also said then that we could do a tax credit, and I'm just saying we couldn't. And I guess if you could back up for me, what is the impetus for this entire, like, what is the sickness, or what is the deficit that we're trying to cure with this?
Well, I think in our memo, the first bullet point that we included was to talk about potential future redevelopment of the 7 PLO sites within the PLO zoning district. And the current regulations require some pretty intensive front, side, and rear yard setbacks, anywhere from 150 feet to 200 feet. So what that does, and what we saw on the Biomed site, was a very small, very narrow building envelope that results because of these very large setbacks, within which any kind of construction could take place. Now, if you want to apply that, if you apply those setbacks to all 7 sites, there are only 7 sites within the PLO. There are only 2 sites within the PLO where the resulting building envelope is large enough for practical redevelopment to take place. In 2 cases, the setback lines, side yard, front yard, rear yard, overlap. And so there's absolutely no place for new construction to take place on 2 of the sites of the 7 in the PLO under the current zoning ordinance. They could try to renovate existing buildings that are there and use just what's there and the same amount of parking and lack of green space. That's all you'll ever get from those 2 sites. And there are 3 other sites where the resulting building envelope is so narrow and so small that for practical purposes, new construction won't take place either. So you're left with 5 of the 7 sites having very little in the way of potential future redevelopment for improved circumstances for the community.
But how is it an improvement to allow more development? See, this is again, and we talked about this 2 weeks ago. I just reject the premise of this, which is you're trying to fix something that isn't broken. And it seems to be the motivation is to increase revenue for the township, presumably to expand the government and the size and scope. I just don't understand what the goal is, because we're trying to fix something that's not broken.
The goal of a draft zoning amendment is for better land use.
Well, why don't we
Strictly and
look at the
only.
entire ordinance then? Why are we picking on the 2nd ward, right? These are all my sites. This Villanova was also in my neighborhood here. This is 2nd ward being overdeveloped, and it's amazing because we get the other commissioners that are ganging up to outvote the one guy to put all the development in his ward, and to the detriment of the 2nd ward neighborhoods. And I disagree with Commissioner Higgins in his last comments in the prior segment, because we didn't allow Villanova to do what they could build. We rewrote the law for them. You are doing that again, Mr. Gabriel and Ritu. You are rewriting the law so that one developer can get an excessive amount of development, as Villanova did, excessive. But this will be worse, because this will be even worse, and it's going to be in the same corridor.
Rich, you sound like you're scolding him. If you want to scold anybody, scold us, because we're the ones that voted to authorize this company to proceed with this approach, with this ordinance and this process. So just scold me if you want.
Well, actually, I'd like to suggest we tell Steve to sit down and we just allow Biomed to build 480,000 square feet of offices and put all that traffic in your ward, Rich. You just don't understand.
I love that. I don't understand.
You're clueless.
I have 3 degrees.
Okay,
All right, now listen.
let's be more constructive about this. Okay?
This isn't constructive.
Are you
because,
finished, Rich, with your comments?
No, I'm not. What the issue here is what are we going to do to maintain the quality of life and require adherence to our standards? What you want to do is let a specific developer exceed standards, to overbuild.
Rich, that assertion is false.
It's not false.
Since
it's absolutely
day one,
true.
we have been just as interested as anyone in mitigating the traffic over there.
No, you haven't.
You're wrong, Rich. That's a claim by you that is not factual.
Let's revise the zoning in the 5th ward.
Go ahead.
Let's do that.
Where are you going to do it, Rich?
Let's do it tonight.
Where are you going to do it, Rich? Come on over.
Let's put it.
You don't even know where the 5th ward is.
Let's put in a new PLO, a new zoning ordinance in the 5th ward instead of the 2nd ward.
Let's let Mr. Gabriel finish his presentation, and we can privately discuss and debate what we're trying to do to one another. I don't see that we're trying to hurt you at all, but let's just let Mr. Gabriel finish.
Okay, again, Jim, the reason being, and we brought this up to Mr. Gabriel last meeting, all 7 of these sites that you are talking about changing the zoning to allow increased density are all within the 2nd ward. Yep. Villanova was just allowed to massively overbuild in their small area, and it's right there in the 2nd ward. Again, I'm happy to have everyone build. I'm a proponent of business. I'm a conservative. I'm a proponent. I'm a Republican proponent of business and free enterprise in America. And Radnor, all I want is to maintain the rules that we have, to apply them equally and fairly to everyone. And what we are doing is crony capitalism and picking winners and losers based on what money we think we can get. And I'm
Rich, can we
and I'm
please
totally
hear from our
opposed to it.
consultant now? Thanks.
No, I'm not insulting. I'm not insulting anyone.
I said, can we please hear from our consultant now?
I'm waiting to hear what is the evil you're trying to solve?
Well,
You
again,
said
Rich,
you want to increase density.
It was this board that commissioned Ritu to do it, so please don't single him out. He's a professional. He's an expert in this field. Let him make his presentation, and then when it's all over, you can criticize your fellow commissioners for doing the wrong thing.
I will criticize my fellow commissioners, but the premise of the study has to be, this is the problem we are trying to solve. That's my question of my expert.
Well, go ahead. Please finish your presentation.
We'd love to hear the end of your
As I mentioned, one premise or one reason for adding and modifying the regulations is to enable for better redevelopment of those sites as time goes on. The second would be to try and address traffic in a way that actually manages it and doesn't allow for increased traffic. As a result, really doesn't result in increased intensity. And we've done some traffic scenarios to try and test square footage and resulting trips generation to show you a little bit about what results. The interesting thing that we have discovered or found in doing that is we did another sketch plan on the biomed site. Since we were more familiar with that, we had drawings and so forth. We came up with about, under the proposed amendment, we came up with about 625,000 square feet of space that you could build with a mixture of uses on the site. So we knew that within the regulations, there was room for additional square footage over and above the 475,000 that isn't on the plan in front of you. So then we said, all right, well, let's test that out. What's the resulting traffic from 625,000 square feet with the mixture of office and some apartments and a hotel? And we found that it was far in excess of the traffic being generated by 475,000 square feet of office. So that gave us a little bit of a pause. So we've done
Wait, I'm sorry, you said it was far in excess of what?
Far in excess.
Because of the use of the subordinate uses were more intensive than the parameters, the logistical parameters would allow.
You can fit 625,000 square feet within the height restrictions, setbacks, and so forth, but the traffic that results from that
is too high.
Is too high
That's
for the traffic
interesting.
neutrality that we've defined in the ordinance.
625,000 relates to what again?
It's a mixture of uses. And that was the other reason I think that the Board of Commissioners and the Planning Commission have been interested in having this mixed-use overlay evaluated was they viewed mixed use as a better form of development than strictly all office. It provided more value to the community. So that's why we've been focusing in mixed use, and we would agree, especially given the location of these sites, so close to the Blue Route and Lancaster Avenue interchange.
And I know everyone is going to be mad at me again, but 475, we throw out these numbers, 475 is not a universally recognized number that could be built there today.
It's a plan that's in front of you, though. We're only using that as a benchmark because it's a plan in front of you and everyone's familiar with it. Whether or not you all decide that you can build on it is you're right. It's not set in stone.
It's not set in stone. It's not agreed to, and my view is that wouldn't be permitted. Something closer to 300,000 square feet is what the site would reasonably hold under our current analysis.
Let me show you the results of these traffic scenarios. Scenario number one, as we've got up there on the screen, 300,000 square feet of office, 150 dwelling units in mid-rise apartments. That translates to, roughly speaking, 150,000 square feet of building, of floor area, based on 65% of the units being required to be one bedroom, required by the ordinance to be one bedroom. So your units are going to be a little bit smaller, and that's why we're just using 1,000 square feet as a basic number per dwelling unit. 160 seats of a high turnover sit-down restaurant. This is comparable. 160 seats, 5,000 square feet is comparable to an Applebee's. Both of those numbers fall into the range of development that you'll see from an Applebee's restaurant. And then a health and fitness club, 25,000 square feet. And when you look at the traffic generated by the total square footage, floor area is 480,000 square feet, very comparable to the 475 plan. The traffic generated total in the AM peak is about 50 trips less than the all office. Total in the PM peak is 8 trips more than the all office. But what really caught our attention, so we're seeing comparable square footage, comparable total trips, but looking at the AM peak, the entering numbers for the mixed use versus the all office, there's 96 less trips in the entering, which is the more intense movement in the morning. Similarly, the exiting movement in the PM is the more intense movement in the PM, and we're seeing 71 less trips for the mixed-use development
But
in the
where
PM
is,
peak.
you're not showing us all office as a comparison here.
Yes, in the red is the all office.
Oh, I
is the
thought that was a
all-office
total.
plan.
I'm sorry.
I'm sorry. Yeah, that's the all office plan and their trip generation. And these are all trips as based on the ITE trip generation tables. So
I mean, this is so interesting because to break it down now more between, so it's not just rush hour traffic, it's now we're looking at a difference between entering and exiting. Is that, professionally, does that make a difference? Those are all cars on the road at that point.
yes, they are. But in terms of cars approaching a particular intersection or traffic signal from a particular direction, it's less. And I think this was a point made by Gilmore Associates a year or so ago in evaluating the MUST ordinance and just talking about trips generation in general. And wasn't expecting this, but that's what these, and that's a pattern you'll see in all 4 development scenarios. While we try to come up with combinations of uses that made sense and were marketable, we saw this kind of lesser trips on the more intense movement, entrance in the morning, exit in the evening. So it starts to address what you had raised 2 weeks ago, Commissioner
Right.
Schaefer, about reducing actual traffic by 10%.
Right.
And then
So even if it's the same amount of traffic, it's better traffic.
Yeah.
Because it's not everyone entering and everyone exiting at the same time.
That's right. And it's sort of along the lines of what we've talked about with a mixture of uses, that some of those uses have I shouldn't say PM, but peaks at times that don't match the peak on the street. And they spread their traffic out at different times of the day. As a result, helping
We could
the result.
soften the mixed use, could we not, by encouraging somehow, or just passing the ordinance that says the general office, the 300,000 is a high number. and the mid-rise apartments is only 150,000. So we could play around with those so as to reduce the number of entering in the morning?
Well, yeah, and we did a little bit of that in these. We have 4 scenarios up here, and what you suggest, Commissioner Higgins, is what we see a little bit more along those lines in scenario number 4. And the other interesting thing here is that it was a challenge to come up with combinations of mixed uses that resulted in more square footage and stayed within the baseline 475,000 square foot of all office in terms of trips generation.
The traffic trip generation, the neutrality requirement is really driving this to keep the density down.
Yeah, I mean,
more than you expect, more than any of us expected.
As I said, 625,000
Right.
square feet under the ordinance regulations, but we couldn't get to 625 under the traffic neutrality requirement. And traffic neutrality even and also has, I guess you could call it a plus in that when we talk about the most intense movement, entrance in the morning, exit in the evening, being less than the, and that's even true in development scenario number 3. We have 553,000 square feet of mixed-use floor area versus 475,000 square feet of all office floor area, and yet the entering in the AM peak is almost 130 trips less than the all office. The mixed use is 130 trips less than the all office. And the exiting is almost 100 trips less in the PM peak than the all office.
And these are all numbers derived from standardized, I won't say tests, but standardized formulae?
Well, they're really, they use case studies or case examples of developments. So where we had trips, and we have a main table that talks about a multiplex movie theater, they'll tell you that they have that based on different multiplex movie theaters around the country. They study those to find out, okay, how many trips are being generated by the one in California or the one in Pennsylvania or that sort of thing. And so they try to develop a whole host of examples so that, the numbers come together in they're not skewed. Right.
So, what do you think? With your experience, are these going to be attractive, an attractive alternative for a developer rather than just going all office? They're not really getting any more density.
They're not getting that much of an increase in floor area. 3 of the 4 scenarios, are not an increase. Only 1 is. I'd certainly like to hear from developers who have an interest in the PLO, particularly. But I think what we've heard from Biomed and from Brandywine, principal owners of almost all the PLO properties, is that mixed use is a better way to go for them.
Well, because
in terms of value.
Right, they have an interest in the traffic as well. So sticking all office is going to hurt I'm sure they understand that's going to hurt their tenants in the end anyway.
Yeah, certainly looking at lease rates in Radnor, in the Radnor area, general office is still generating more in the way of lease income than mid-rise apartments do. But I think the interrelationship of uses and the way development these days is going, a mixed-use development is still the preferred way of going. Whether additional square footage is a real need over what an all-office would allow, really need to hear from the principals involved.
The whole premise here is you established a baseline of 475,000 square feet, that's, I thought you said you were going to, you said, hold on, let me look at it. If a baseline with 300,000 square feet were used, what would this look like? In other words, 475,000 square feet is a made-up number. It's not. It doesn't govern. There's no approved plan, and when you present it to these folks and to the public, they think, oh, it must be what it is. Stephen Gabriel said it is, but it's not. It's not an accepted number.
Well, let me state right now to the television audience that it is not a made-up number. It is a number that came from a plan that's in front of this board right now.
It's not an approved plan.
That plan is not approved. It is simply a number to make comparisons with. We can do this for 300,000, 200,000, 600,000, whatever number you would like to use. And I should also add
300,000
that among the 7 PLO sites, 300,000 square feet will be too big for a couple of them, and 600,000 would be woefully short of what one of them could put on their property, whether it's right now or under the proposed amendment. So 475 is just a number within a large range of square footages that would be possible on individual sites.
Can I just follow up
Small on
with that
some
thought?
sites, larger on others.
So that one site that has the propensity of a lot more than 600,000 because of the size, they're under this, as it's been drafted so far, they would still be reined in by current traffic. So even though in a theoretical
That's right.
world they could fit all that on, they would still, the marker for them would be the traffic they currently generate from their property as it's being used now.
That's right.
And we wouldn't allow them to use some imaginary, what they could put on there.
The ordinance allows for two different ways of calculating it, but it's based on existing square footage on the property as the baseline. That seemed to be the fairest way, the most predictable way, since there is a lot of disagreement still on what a by right plan is under the PLO. And as I've pointed out, for two of the sites, they can't build under the PLO right now.
Well, I would also add that these developers have no regard for traffic, and whatever square footage that will make the most money is what they will use. So I just disagree that they will see some kind of restraint from traffic. And also what they'll do is they will manipulate and stretch and work the numbers to maximize what they can do. The existing site for the biomed location has zero traffic. Zero traffic today. There's nothing there. There's nobody. So all of this represents a huge increase. Huge increase in the traffic.
Today, but not as compared to when that building operated and had lots of traffic, enough to bring traffic police officers out there to manage it. But this amendment is a choice. It provides developers another way of developing on these sites. They don't have to do that. Right now, they could build for whatever it is that the ordinance would allow as all off.
Understood. I just cannot get behind, and we have a vast difference, and I have a vast difference of opinion with this board, if they're trying to make a site attractive to private developers. That's not my goal, and attracting more development in the neighborhood is simply something I think is outside of the role of government. So
Okay, so let's move on and.
Before we do, I guess your firm, do you look at marketability? So what kinds of things, you mentioned that you've talked to developers. So right now, the marketplace around this area is maxed out practically. So what gives a developer a leg up in that kind of market? Do you have any knowledge of that kind of thing?
Well, I think what can give a developer a leg up is the ability to develop in a mixed-use fashion, because then they're not hemmed into one particular use or another, that they're able to blend to the degree that the amount of space that they think is still marketable. We could say that, there's a lot of office space available, and so an all-office development might not make sense. But a mixed use can, because you can start to work with the numbers to make it better fit the market. You've got more flexibility to fit the market.
Okay, thank you.
I'm really, really intrigued by this chart. I mean, this is not what I expected at all, and I'm sure I'm not alone. And in terms of what's in the draft and moving forward, I think I gave my thoughts, about all my thoughts last meeting, so I don't really feel the need to give you more of my thoughts. In my opinion, this is ready to be put in a draft ordinance and be given to one of the Planning Commission, not just one of our boards, the Planning Commission, for them to look at. I think seeing these numbers as an example that is very helpful. I have to say I'm a little worried about the utility of this ordinance, seeing these numbers, because I'm worried about the incentive factor. But this is not my bailiwick. I don't know these markets. I don't know what drives these firms. Mixed use is going up everywhere, so there must be something to it. And I would so much rather see developments that incorporate all of these elements than all office all the time for the next 30 years. I think we would be naive to think that there isn't going to be redevelopment of our PLO sites over the next 10, 20, 30 years. There will be. Buildings become outdated and people buy and sell and invest in their buildings. Right now, all of that redevelopment will be office because that's all that's allowed. And I think many of us have come to the conclusion that that's not what we want, given the traffic generation of all office. And in my opinion, on a more global, it is the level, it is the function of this board to think, to have some vision to the future and what you want your redevelopment to look like. If you stomp your feet and say no more redevelopment, we like everything the way it is, we're going to end up like 69th Street. You've got to change with the times. And redevelopment of your community and your business community is a good thing. You just have to make sure it works for your community. And to me, that's what this whole exercise is about. The way it's going to work for our community is keeping the traffic, controlling the traffic. So anyway, I would like to propose that we move forward with this. I would love to see a real draft ordinance. I'd love to hear from my colleagues, but I'm happy with what's in your draft. And I would love to see that turned into an ordinance, a draft ordinance, and presented to our Planning Commission. There aren't things that I would like to, the one thing we need more information on is the medical office. We never really got a good answer about, how that's different than office and what the, so I'm not completely sold that use should be in there, but we never got all the information on it. So and here's the information on it.
I didn't include medical office in any of the scenarios because of, well, we had one from an older scenario, and it just blows the traffic out of the water.
Right.
And you can see that on this chart. Medical dental at 200,000 is 378 trips entering, which is more, and 100 exiting. So you have almost 500 total AM peak hour trips for 200,000 of medical office. 250,000 general office only gives you 400
right.
total
It's
trips.
Worse than office.
So
yeah.
You could fit maybe 150 tops 200,000, but maybe 150,000 square feet, and I think that's close to what Penn Med has now on a site with a little bit of other smaller mixed uses, and keep your traffic equivalent to at the number 475 of all office. But it's a tight fit.
Okay.
So that's why we didn't include any with.
Well, if we could get doctors to not stack their office hours in the morning and spread them out in the afternoon, we'd be better off.
Well, if you go up to Bryn Mawr, where they built the new medical arts pavilion adjacent to the hospital, it's a disaster area. The parking's absurd, the traffic, the people think nothing of double parking and blocking the street. And that is constant all day. It just never seems to wane.
And that would certainly be a concern we would have about really putting a cap, a really strong cap on parking made available on site, that you'd start to get that spillover kind of activity that you wouldn't want.
Right. Are you finished, Commissioner?
Yeah, so my sense, I just have the general concern that I think this has become much too complex. It's going to be a tough sell to the community. To me, the solution, if there is one, is much simpler, so it's easier to explain to Rich that it's not problematic. That's essentially the where I see we could go or should go. I just think this is going to be awfully difficult to get through the community because it's awfully complex.
Well, I mean, there are a lot of numbers here, but an ordinance, once we agree, I don't want to jump the gun here, but we're not going to have more than one scenario, are we?
I'm not sure what we're going to have. I think
Okay.
we're going to.
Would you be opposed to seeing a draft ordinance?
I mean, why would I be opposed to seeing a draft ordinance? If it were me, I would make it dramatically more simple. And
Well,
I'm not
maybe
sure
when you
that,
see the ordinance, it won't seem so complicated.
Okay, maybe.
Steve, these charts, have these been given to our management?
No, I'm just making these available tonight, and we'll certainly get hard copies to everybody.
All right, so we'll
Yeah,
have those, as
electronic
our
copies.
board members will have those?
Mhm.
All right, thank you.
Yeah.
Good.
Yeah. And Commissioner Curley, is there anything that is part of the document right now that you would feel ought to be just eliminated? I mean, like, there are a bunch of sign provisions, and perhaps some other aspects that really don't get to the heart of mixed-use redevelopment and managing traffic. And maybe that's a way to help simplify.
I just see taking the use that is allowable and opening it up to uses that are dramatically less traffic intensive. And, that's it. And there could be some parameters about how big the site would be. But, an example would be that mitigation fee. When you have those mitigation fees, that to me screams to the concern that Rich has, that you're trying to put more traffic in there, but we'll figure out a way to manage it more by putting in turn lanes and, things of that sort. So as I see this, is just opening up the uses marginally with clearly less intensive uses. And then if a developer wants to develop under those uses, we would allow them to use it.
Last time you had mentioned trying to provide more, instead of traffic or roadway improvements via that fee, that not necessarily with the fee, but you wanted to see more in the way of transit incentives.
Yes. So the idea there is that, this is the classic example that we've encountered from the people that we listen to talk about Villanova and Villanova and Biomed. When they, during those traffic intensive times, it is difficult to pass through that portion of the township.
Mm-hmm.
So the general trend that I think we move in is we start taking some of those discretionary trips that would have us pass through, and we start putting them on either end. So that's opening up some of these things to retail so that people don't have to pass through this congested area to go have dinner. They can just come to the perimeter of it and, park inside and have dinner there. So I just sense that what you're trying to do is orchestrate something and then show to us that once this is orchestrated, it will be more successful. And I think I'm going to have difficulty with it. I think I just want it to be dramatically more simple. And if it doesn't get used, so be it. But it's out there to be used for one that would be willing to develop under it.
And finally, what I would say is that this is much more likely to have the neighborhood end up like 69th Street than doing nothing or making some other provision. These more intense uses, you can see from the traffic that's going to be generated, and it does seem to be orchestrated because I see it's apartments here, but it's difficult, it's impossible to believe that a site that has 800 spaces today and this site with 1,600 or 2,000 spaces is going to have the same traffic. So again, the premise here is faulty, that 475,000 square feet is a rational number. The premise is faulty that that's the traffic we should be attempting to go to. If you looked at the Wyeth building in 2002 when it was fully operational, it did not have near this number of trips. It didn't have it. And to say today that that's what it was or that's what we should design to is a fallacy. And again, this is not going to result in better or neutral traffic. The best possible scenario is to not hurt the traffic, which would be massively worse than it is today because there is no traffic at all. And also, again, it should, if it's not, it should be, and I will call on all the commissioners, because I'm first, you will all be next, your constituents will be next. It is improper for this board to be voting 6 other commissioners to have a zoning amendment that only affects 1 ward. It's especially when you're talking about increasing density.
I don't look at our obligations here as to as supporting or
yes, you do.
or advancing the concept of sectionalism.
You do.
I think we're collegial. I think we all work for one another.
No, we don't. You are changing. You are voting on increasing zoning and density in one zoning code, one zoning district that affects only 1 ward. It's improper.
But the first ward has heavy commercial.
All right. Well, then
now.
let's put the PLO in the first ward.
No, we already have commercial.
No, you don't. You don't have PLO in there.
No, but we have commercial.
Well, let's change your commercial to increase the density.
Let me try to turn the discussion. I would like to have your company prepare a proposed ordinance along the lines of what your memorandum is talking about, with some suggested scenarios accompanying it, and I'd like to have it to us for the purpose of getting it out in the public and reviewed by our Planning Commission.
I'm completely with you on that. So is that a motion?
Yes. Don,
I'll second it.
Are you?
I just don't know. It's not going in the direction. I'm going to come up with some of my thoughts on my own. I'll bring it to the next meeting.
I know, but we do that every meeting. So,
Okay.
At some
I'll have to
point.
step it up. But I see this going down a direction that I think is problematic, and I don't see myself supporting it. So I don't want to
Okay.
jump into this now because I think it's become too much like the last one, too complex.
All right, that was my motion. Is there a second?
I second it.
All right, is there any discussion amongst the commissioners? Anybody in the audience that would like to say anything? All right, sure. Mr. Goodman, come forward, please.
Hi, Lloyd Goodman from the Radnor Racket Club. I had a chance to walk my site. It's at 175 King of Prussia Road between the Biomed site and one of the Brandywine buildings. I guess they call it the Radnor Financial Center. I walked it during the wintertime with Mr. Gabriel and my attorney, and then planned to get a urban planner to help me along, with my kind of unusual site, 7 acres. I'm one of those sites that would be totally unbuildable now under the PLO. Plus, I also have a stream going right down the middle of the sites. That also complicates things. But my site is kind of special in a lot of ways, too, that the urban planner I had pretty much hired March 3rd then declined to work with me, so now I'm about ready to hire somebody else. And Mr. Gabriel was very good to say before, he'd be happy to hear what we have to say. So, I mean, just a few comments that I have on my own that I put together. I'm probably not going to take people's time now because Mr. Gabriel was so cooperative.
Go ahead, please.
Well, just a few about some of the things I'd seen about the traffic neutrality, which sounds great, but at my site, we have like no traffic at peak hours. I mean, we have the indoor tennis, which is spread out over the day, 3,000 square feet of office space, which is not much, compared to everyone else around there. And the 6 indoor tennis clubs, 6 indoor tennis courts, and then the 200-seat banquet facility, which is really Friday and Saturday nights or Sunday afternoons predominantly. So my site, to make that traffic neutrality compared to what it's doing today doesn't seem really fair at all. And then especially on paragraph number 4, special regulations, one where it's specifically related to general offices. Well, I have 3,000 square feet, so you don't want a 7-acre site. That's nothing, negligible. And then the next one says total trips for all, the existing buildings. That would include the banquet facility and the tennis. There again, it's really not anything to speak of. And then where it's below it says about number 2 there for sites less than 10 acres, this might just be kind of a grammatical thing. It says there shall be no minimum number of the uses established, which is good, so that means we could have one use. But then it says for applications proposing more than one use, it lays out these percentages. But what if you just have the one use? What do you do? I mean, so maybe that's a grammatical or just some.
I'll be glad to.
Okay.
That's all right, Lloyd. I'll go back to traffic first. And we wrestled with what would be the baseline to compare the new development's traffic with old development or old traffic. And what the language in the ordinance says is existing square footage, regardless of how it's being currently used, and this was recognizing, in at least in part, your situation, Lloyd, regardless of how it's being currently used, it's the amount of square footage on the site as if it were in an all-office use.
Right, that's the way I read it when I read it. That's the way I understood it.
And so then, still, like you said, we don't have much in the way of traffic. But the alternative way of calculating is to assume all that square footage is all office, and then use the ITE trip tables to calculate what the traffic would be if that were an all-office development based on current square footage at the site.
Okay.
So it's whatever you have there as an all-office development, and then looking at the trip tables for all-office traffic. And you compare your new development with that.
Okay, I must have missed that. Like I said, I didn't really get a chance to examine that carefully,
And then the percentages. If it's for sites less than 10 acres, if it's only one use that you're proposing under the mixed-use development, then you don't have to abide by those percentages. Those percentages, like 75% office, 35% multifamily, 75% hotel, only apply if you have more than one use being proposed in your new development.
Okay, well, first of all, with the existing square footage, basically we have one floor. Here you're proposing possibly up to a 6-story building. With my square footage, that there again relates to not much of a development, if that's what you're saying.
But we're assuming your existing square footage is all office. That's a whole lot more traffic than any of the other uses other than office.
Okay, so
that you might propose new.
So I missed that. I'm sorry if that's in there. So that's why I want to get my land plan involved so you can work with
Some of us up here missed it also, so don't feel bad.
Sorry. So I appreciate Mr. Gabriel explaining some of that, and I apologize for not being as well versed as I possibly could, but that's why I do plan on doing this very shortly. And that way I would understand it better. So anyway, I think generally it's a good thing to do because, I mean, whether it's 69th Street or other places, you do see, developments that, people at one point think, oh, this is great, but they do in time really run out of their usefulness. And this particular area is not like anything else in the township, I think, with the highways and the transit, to just say, oh, well, somebody else's district, I don't think that quite fits. And also one thing that I'm kind of hoping that things can be made very useful would be something like assisted living, because that really has great spread of traffic, and also the workers that tend to work at those places, or a great many of them, are already taking mass transit. You don't have to incentivize them so much. Thank you.
Thank you. Did you consider assisted living, Mr. Gabriel, in any of your?
Yes.
Yeah, it's a yes.
Is it in there? Okay.
Yeah.
Yeah, skilled nursing and/or assisted living
Yeah. Okay.
facility.
It's a
We did
yes.
not put that in as far as traffic goes. The invite. Thanks, John. Yes, we did. It's one of the permitted uses under the mixed-use overlay.
So it's the 11 o'clock hour, and there's a motion and a second.
Yes, and there's nobody else in the audience that wants to speak.
I'll be 10 seconds. George Brosman for Brandywine, who owns a lot of property in the district. I've said it before, but they're supportive of mixed use, and we look forward to this coming forward and would like to participate in the process. Thank you.
Thank you, Mr. Brosman. Good to hear. All right. The motion is to have an ordinance prepared by Ritu for consideration. And I should have said when that would be at our next, in time for our next meeting.
It is informative that the developers are for approving this.
Next week's their next meeting. That's asking a lot.
Okay, we cannot do it by next meeting because that's 7 days from now. So it'll be the first meeting in June.
What are you going to do the first meeting in June?
Logistically, we would then have it at a public meeting and then send it, formally send it to Planning Commission?
Yes.
Yeah, okay.
Yep.
Right, okay.
So,
Don, can you have some of your ideas incorporated?
Yeah, I'll try to bring specifics back as alternatives in
Good.
June.
Great, thanks.
And,
all right.
And Don, if you want to share any ideas that you have with us, we'd be glad to look at them, discuss them, and incorporate as best we can before the June meeting that we would submit.
Okay, I suspect that what I would present would be an alternative as opposed to something that could be incorporated, but let's force me then. I mean, this is what I haven't done yet, but I got to get into the weeds in order to come back with my particular idea.
Okay.
All those in favor of the motion, say aye.
Aye.
All those opposed, say nay.
Nay.
It passes 3-2. All right, that concludes the agenda for Public Works and Engineering. Now we go to Finance and Audit. John Fisher is not here. Does anybody else have anything on Finance and Audit? Then we'll go to Library. Mr. Booker?
No report.
And Parks and Recreation?
No report, the meeting's Thursday night.
No. There is a meeting coming Thursday night for Parks Board. And Personnel and Administration is John Fisher. I don't think there's anything to say there. Public Health, Commissioner Nagel.
No report.
Any old business?
Yes. The old business relates to this continued manipulation of our development ordinance for the benefit of certain favored classes. I see we just have gone through 40 months, as you pointed out, of rancor, of public dissatisfaction, of disagreement, yet a few people on this board insist on doing what the public doesn't want done. And providing a special deal for certain developers is absolutely the wrong thing to do. This what you just approved to go for the PLO district is improper, illegal spot zoning, and the public hates it. The public absolutely hates the authoritarian, overbearing, in-your-face, force it down your throat rule, which is what this board has been imposing on this township, from Ardrossan to Villanova to Biomed. this is overdevelopment, and it's not what the public wants. And I really want you to think long and hard about it. This is negative. It's detrimental to the township. It is not a positive. It's not, in no way enhances the quality of life. And a few thousand or $1 million spent, arguably, is not going to improve the quality of life of my constituents or yours. It's the worst type of planning, and it's the worst type of crony capitalism, and it's overall we're seeing we're reaping what we sow with so many of our constituents who think that the board is not working in their best interests.
Your views are always welcome, at least as far as I'm concerned. Thank you. But I will take issue with one thing, and that is the nature and extent of opposition to the Villanova development. I think the nature and extent of opposition was maybe 50 people when this started 40 months ago, and now by virtue of the number of the people who spoke tonight and in the room, it's down to less than a dozen. And I think when you look at the overall population of our community of 31,800 and the number of people that didn't like the Villanova project and still don't like it, it's less than 1%. And that to me, and I don't get any objections in my district. I haven't. Maybe 3 years ago I had a couple of people voicing concern. But now that they see what's happening, no. I have a lot of people either have no opinion or are supportive of Villanova.
Maybe it will be the case, but rewriting the law to allow overdevelopment is what my beef is. And the people, you stopped hearing from them because they knew it's a waste of their time, effort, that they're not going to convince the board to do what they want. They have one recourse, and that's elections, and elections matter, and we all know that. But that's why there's not a reduction in the people against it. And there's certainly a heck of a lot more than 50 that are against redeveloping all of the, writing an ordinance to redevelop sites in one ordinance, in one ward. That's improper. And again, it's going to, for whatever reason, I'm chosen to be the one who is singled out for punishment from this board and my constituents.
Well, we like you,
but it will come around
we like you.
to all of you at one point.
All right.
And what I will propose, Bob and John Rice, for the next meeting, I would like to have an ordinance to vote on that would require, that would prohibit zoning amendments or overlays or any substantive or substantial changes in any PLO, in any zoning district that would affect only one ward. It's inherently unfair when you can easily get 4 votes to mess up somebody else's ward and they can't do anything about it. So I'd like to see that. I want this board to vote on whether a zoning amendment that affects one ward can be voted on by this board.
Is there any other old business? Is there any new business?
Sort of old but new. As we identified earlier this evening, the park and rec fee ordinance needs some work. This isn't the only dormitory that's going to be built in Radnor. There's other higher institutions of higher learning, and there's potential for more dormitories to be built. So we need to clarify that.
Can we put it on the agenda next meeting?
Depends on what the agenda, how heavy the agenda is, I would say.
I mean, I don't think it's going to be a long conversation. It'd be, just a direction to vote on direction.
Put it on for a discussion, yeah.
All right, let's ask to do that.
Is there any other new business?
Just think on the one item there. John, and I don't know on this with Rich, with the one ward, with the zoning affecting one ward. I'm not sure whether or not if you can do that, to actually limit like a zoning amendment to?
Well, any,
No, it's not a zone, it's a resolution that this board will not vote to change zoning, especially to increase
Listen,
density.
listen.
When only one ward is affected by any such
all right. Well,
zoning
John,
change.
there are not going to be 4 votes to do that work. So,
yeah, one commissioner can't direct
yeah.
us to
No,
do
we
that.
we can bring
You can make a
one
motion if
commissioner
you want.
can bring anything before the board. It was voted on by referendum.
That's not what you asked. You asked for an ordinance to be prepared.
Yeah, you wanted something, I mean,
Put that on the agenda.
it can go on the agenda and discuss then, whether or not to direct the staff to do that. I mean, practically, I don't think that's a proper zoning amendment under the MPC. You're
It's not a zoning amendment, it's a resolution.
But then it wouldn't have any effect.
It would have the effect of binding the board to their resolution.
I would, it can be on the agenda because one commissioner can put any item on the
Yeah,
agenda.
so just put it on there, but don't do any work, because it won't be 4 votes.
Because why? How do you know there won't be 4 votes?
Because
How would you know that? Are you colluding? How would you possibly know there wouldn't be 4 votes?
We'll place it on the agenda, Rich.
I know
We'll
my
get it
fellow
done.
commissioners, and they don't subscribe to sectional.
No, they do. They subscribe to sticking it to Rich Booker in the 2nd Ward.
I don't. Okay.
Okay.
Is there
Move to
any
adjourn.
public participation? Is there any adjournment? Does anybody want to have an adjournment? Second?
Second.
We're adjourned.